Yes, sir.
Please, Your Lordship. Pardon me because I can't got the file due to rain. The clerk is a bit delayed.
So you pass on.
No, just a kind mention, my lord.
But I can't pray. Rains go away. Little Johnny wants to play.
My lord, secondly, I have to file a withdrawal memo for the.
You want to withdraw this petition?
My lord,
So give memo to you. Paper to you.
we've already prepared the memo, my lord.
To withdraw. One more. There is no respicator for memos. The counsel for the petitioner seeks leave of the court to withdraw the petition, assigning no reason.
No, with the liberty to file a fresh with better particulars.
Effectual of the same cause of action. First of all.
Updated cause of action, my lord.
Updated cause of action. Same or fresh cause of action. Leave having been granted, petition is disposed of as having been withdrawn. As per law.
Item 2. May I please? In this case, petitioner, who is the chairperson of the school managing committee of Vipada Bhanjani Upper Primary School, Sahabad, seeking for re-implement of one assistant teacher. Seeking for re-implement of one assistant teacher.
I have not understood any. Make first statement.
The petitioner, who is the chairperson, my lord, seeking
of the committee,
my lord, of the school managing committee, my lord, seeking for re-implement of one Simati Vijayalakshmi for one assistant teacher of the school was retired 36/2025.
Sanction re-employment.
My lord, as per provision of the rule 19.
Board is pending for the director for approval.
This is the recommendation, my lord.
1525 is recommendation.
My lord.
Recommendation by whom?
By the
By
president.
the president and chairperson to the director elementary, OP number 2.
Sir.
Officer 4,
Yes.
page 16.
This is sent by the president of
President,
that school, school committee.
School committee, my lord. President and as usual chairperson of the managing committee.
Resolution is passed, a post is approved.
Resolution is annexed 2, my lord.
Resolution is dated.
Dated, my lord, 30th April 2025. As per provision of the rule 19 of the Odisha Education Recruitment and Condition of Service Teachers and members of the staff of aided education institutions, rule 1974.
Rule 19.
19.
Of you write down that rule.
Well, Odisha Education Recruitment and Condition of Service of Teachers and members of the staff aided education institutions, rule 1974.
So request is made for
Re-employment, my lord.
to take steps for re-employment.
My lord.
Sanction of this letter before 36/25.
Further period 2 years.
That is not considered.
Not considered, my lord.
Where is your representation?
Annexure 4, my lord, is the
Your school is before
school
you?
is my lord.
Committee of the school or school?
Committee of the school, my lord. Committee of the school, my lord. School managing committee of the Vipada Bhanjani Upper Primary School.
What do you say, Mr. Lanka? Consider that.
Yes.
Kindly be seated. Listen to me. Petitioners, the school management committee is pleading against non-consideration of its representation dated 1/5/2025, wherein a request is made to the Director of Elementary Education to take steps for re-employment sanction of a particular teacher on or before 36/2025. First off, the short representation is reproduced for ease of perusal. Next paragraph. Counsel for the petitioner submits that this representation has been made under Rule 19 of so and so rules. See that in that representation rule is mentioned. Okay. Rule. And all formalities having been complied with, comma, the same has been submitted for the consideration of jurisdictional vote. But he also complains that The representation is kept pending with no justification whatsoever, and therefore the indulgence of this court is eminently warranted. First, next one. Learned AGA Mr. Lenka, on request appearing for the OPs, in usual fairness, submits that the representation needs to be considered in a time-bound way and on its intrinsic merits at the hands of the Director of Elementary Education, and that the same shall be accordingly done. First off, this is appreciated. He tells the court to prescribe a reasonable period to facilitate consideration. First, next paragraph. Diction of this rule of gates. Okay. If delay is caused, open to solicited. If delay is caused, it is open to the petitioner to move an appropriate application seeking an order for levying of heavy costs on the official concerned and payable personally by him. If they do not do, move application, I will levy heavy costs. No contempt, nothing now. Yes.
Only framework, this is not a recommendation, this is a recommendation.
Anyway,
Okay.
read the recommendation, representation.
Obliged versus.
Next. Mr. Lenka,
Yes, ma'am.
you have to call your officers for a meeting. Your Advocate General, yourself, and your secretary. The writ court is not meant for passing orders on representation. Consider. How many cases every day? Why litigant? Why should not you form a committee as to what has happened to the representations? You mean to say every minute the government spends 2,000 rupees for one court? Every minute. See the CAG report. I will impose cost now hereafter. I have seen all these 5 months. Consider representation. This court is full of representations. What is use? Why court? They should come to court. You ask your officers to come to the court here in the open court. Meeting will be in the open court. Let them face the lawyers. Then the meeting will be in market. In Balipada Yatra is happening. That market will that. Let people know that government is not doing its job. I am not against any party or anything. I am against the government. Every day, how many cases? Consideration. And they are also not considered. Then contempt. Then again in first contempt, second contempt, third contempt. What is this happening? No, when are you bringing your officers here? Your law secretary should be here in the open court, no in the secret meeting. I want to expose the government. I want to expose your officials to the eye of the public. Let people see what the officers are doing. They are getting salary, they are getting pension, all perquisites, everything. What about common man? What this third-rate thing is happening to the common man at the hands of the government? This is not the way. I will defame the government. This court will defame the government. This is too much. Every day I am seeing our whole writ jurisdiction being converted into order for consideration of the representation. This is not for Dr. Ambedkar never intended that the writ jurisdiction should be used for such things. It is for greater things. Why you are not forming the committee? In all representations, whichever is made, there should be consideration. And they should know the result of consideration. Only then they should come to the court. You to tell the officers, do your job. Constitutional court. You have reduced it to the level of the JMFC court. No, next time I will not allow these things to happen. There is a limit for these 20-25 matters are again coming before me. I am warning the government. I am warning your chief secretary. I am warning the secretaries of all concerned departments. Hereafter, if any citizen comes before the court and says, I have given a representation, it is not being considered, heavy cost will be imposed. Heavy cost will be imposed. Mr. Advocate, I am telling you also, Behra, you should tell your officers. Otherwise, court will defame them. It will have repercussions on the government. Kindly think about that. We are not here to please your officers. We are here to protect the citizens. What you have done? If you put that, if put standard format, if representation is not considered the time and the result of the consideration is not informed, here because of this criteria, time is not necessary. The concerned officer shall pay to the petitioner rupees 1,000 per day till the task is accomplished. And that amount shall be payable from his pocket personally. Yes.
Obliged.
Yeah, after this kind of orders. Yeah.
Obliged.
Next. Item 3.
But I have challenged the order of punishment under Annexure 6.
Punishment.
Yes.
What is that punishment? What was the
That is
charge?
the termination. Punishment of termination has been awarded on the basis of an inquiry report, purported inquiry report, where inquiry has never been conducted.
Because the report is not given to you.
No, neither the inquiry report nor I was noticed to appear before the inquiring officer. Nothing. That I have taken in my ground.
Emergent notice. Then cards of notice for the OPs. Any private party?
No.
We have filed appeal. Appeal before
The
the.
appeal is pending.
Appeal will direct the appeal to be disposed of in time.
But during pendency of writ petition.
Not pendency. Because appeal is pending. We cannot decide. We tell the appellate authority to dispose of the appeal.
2 months.
3 months. Outer limit, 3 months. The short grievance of the petitioner, regardless of the prayer, textual prayer in the petition, is as to long pendency of his departmental appeal against the punishment order dated 29/3/2025, a copy whereof awails at Annexure 6. First, learned counsel for the petitioner submits, and this court agrees with the same that
Appeal is Annexure 7.
the appeal of the kind, which is reflected in Annexure 7, cannot be kept pending in eternity, breadwinning of the party being at stake. First, Mr. Lenka, do you agree that I should? Sure. Learned AGA, Mr. Lenka, very clearly agrees that this appeal should be disposed of within an outer limit of 3 months in any circumstance. And a compliance report will be filed by the appellate authority with the Registrar General of this court, failing which, on application being moved by the petitioner, heavy costs may be levied on the appellate authority payable by the presiding officer personally. Yes, all contentions kept off. Next.
Item 4 regarding the MSV matter. Lots of things. MSV matter.
Yes, hold on. Next. Item 5.
May I please? Challenging the order dated 25/7/2025 under Annexure 4 alert, the authority is considering the exact allegation filed in the complaint petition. Rather, he passed another order that is totally different from the allegation of the petitioner, my lord. Your lordship, kindly see my complaint petition under Annexure 1.
It's in your language. Which is Greek and Latin to do.
Sorry, my lord, it is my lord, every paragraph.
Just explain to me what is that representation loudly so that your friends will see you. What is that? Just explain.
My allegation, my lord, the petitioner that against the DCP or District Child Protection Officer regarding
Involved in facilitating, permitting legal marriage of a minor girl.
regarding fraudulent or misappropriation of fund by false voucher against the tour expenses, oil expenses, engage the own vehicle in our office
Is there lokaita in your state?
My lord, I have.
I am asking a question. Answer that question. You are bound to answer the court's question. Or you can plead ignorance.
The petitioner is the resident of Hon'Ble.
I am asking you. You are not doing the court.
No, no.
Is there lokaita in
Yes, my lord.
Lokaita is an office created under Lokaita Act. This comes within the malfeasance, misfeasance, misadministration, maladministration. You take up the matter with the Lokaita, the lead court. Any Lokaita Act? Do you have Lokaita Act? There must be Lokaita Act. Orissa Lokaita Act.
When district magistrate did not consider my application,
You go to the Lokaita. Lokaita is made for that. Correct? Learned counsel for petitioner having argued the matter for some time says that he should be permitted to take up his complaint to the portals of Lokayukta under the provisions of
Secure Lordship's pardon, my lord.
Orissa.
Lokaita is not functioning since last 2 years.
Is it? Take emergent notice. Thank you. Somebody should tell me, otherwise I will not be knowing at all. Somebody should tell me. It's not interference. It is helping the court. Because he has not come with full preparation. Yes. Please show emergent notice. To OP number 5. Mr. Lenka accepts notice for 1 to 4. Yes. Next.
Item 6. Item 6, we have Mr. Pathasati Das Melo. Kindly pass over Melo.
Passover. What is this matter, brother? Just open the file.
Melo, no power.
You have no file. Then no right to pass over. Seek pass over. To seek pass over, file has to be there. Yes.
May item 6.
Yes.
Therefore, the direction of the opposite
Brother, don't mistake me. You are all youngsters. When you are sitting here, even your senior says for Passover, you should sit and read the file. That will increase your level of knowledge.
only ask him.
He is not your colleague. Okay. Yes.
For a direction to opposite partner with Tahsildar to issue caste certificate, my lord.
Reconsider the application.
Yes, my lord.
Is there any provision for reconsideration of application of
They, my lord, they taken into the page 12, my lord, annexed 3, my lord.
No, you show me. You go to the prayer. Come to page number. Your prayer page. Prayer column. Read second prayer.
The head order opposite party, special opposite party number 4 to reconsider the application from ESP so and so, my lord, submitted petition for instance of caste certificate in our favor by recalling the order of registration by opposite party number 4, my lord.
Where is the power? Read the section.
No.
Power to reconsider has to be there. Power of review. Unless given, nobody can review the order. Is the judgment of Supreme Court. You have seen that. The versus so and so. Where is your book?
Without proper verification of ROR.
Sorry, where is your book? Show me the book. Where is your book?
Not with me.
The appeal lies before the sub-collector.
You can file appeal, but not review. Unless review power is given. You have not brought the book also.
Appeal is there, but
Appeal is there. Where is your statute book? Not necessary.
not with me.
So I have to go to the library. Take note. Petitioner has structured the second prayer, which is essential reverse, as under. Next paragraph. Petitioner has got alternate remedy of alternate and efficacious remedy of appeal under the provisions of which that act under rules. Which are those rules? They give just writing under the provisions of so, comma. Says learned DGA Mr. Lenka. In the above circumstances, petition is disposed of, permitting the petitioner to avail the remedy of appeal within a period of 6 weeks, keeping open all contentions of the party. First of registry to send a copy of this order to the private parties by speed post immediate.
Item 7.
No private party.
Huh?
Private party.
All are government, but then no private.
Item 7, my lord. The petitioner is a driver, regular driver. He was initially appointed in 1991, but regularized in the year 2007, my lord.
1991.
91 on ad hoc basis, and while continuing as such, he was regularized in 2007, my lord. Since the pension bill has been amended in 2005, with effect from 1/1/2005, my lord, now he is not entitled to get the pension. So he represented under Annexure 3 before the party number 4, basically the judgment under Annexure 4 decided by this honorable court in a coordinate bench.
That they are not considered.
They have not considered. Directly.
Mr. Lenka, you consider that representation? Because the judgment says
State is not a party.
state is not a party.
University, my lord.
University is party.
Yes, my lord.
You take emergent notice.
The opposite party number 2, designation of opposite party number 2 may kindly be permitted to correct, my lord. That is Vice Chancellor BPUT, that should be OUTR, Orissa University of Technical and District.
On request, petitioner, counsel for petitioner is permitted to effect the marginal change in the description of parties, OPs, opposite parties. Petitioner has carried out the same with the issue emergent notice, returnable within 2 weeks. Petitioner is permitted to take serve a copy of the petition on the panel council, if any, who usually represents the university. Okay.
Item 8.
May I please? Here, this is the unfortunate case, my lord. This is a fourth journey of the petitioner to appeal this on court, and the petitioner in the meantime already retired. Now, my lord, the annexure will also directed to
What is that condition?
condition, my lord. That in the approval order, but they have mentioned the clause of tertiary principle. Annual salary restricted 3 years. Your lordship already division was decided the number of cases. Now your lordship kindly see you also get only one.
I'm convinced now. We have a case on admission.
They have assigned the regime. They have passed the imping order on 29/7. The date is important. Now the region has been assigned the writ appeal number 13505 of the state is pending, which covers the case of the petitioner. But that writ appeal already disposed of by your lordship, my lord, in the division bench and case 38 on 17/7.
So they are under wrong impression. It is pending.
17/7, the writ appeal filed by state has already been dismissed by your lordship division bench. Now they rejected my case subsequently, assigning the reason that writ appeal is pending. Therefore, the case cannot be considered.
Writ appeal is disposed of. We'll quash this order and take decision afresh in the light of division bench decision.
Yes.
There will be another round of litigation. So your lordship may issue notice.
That's right.
Short date, we already retired, my lord.
Yeah. Issue emergent notice. Mr. Lenka is requested to accept notice for 192, emergent notice to 3. 3 also you appear.
No, 3 is governing, but 3 may not be required for the purpose.
But you have made him a part.
Yes, note.
Emergent notice to 3. Returnable within 4 weeks. 4 weeks. Yes.
Item 9.
9, my lord, this is my lord. Covered by my lord Loknath Behra's case, my lord.
Loknath Behra.
I have corrected the.
Other day your lordship was inquiring whether the appeal has been filed or not. Yes, writ appeal has been filed.
Any interim order granted?
Not at least.
Not yet. You take this also and be disposed of.
Item 10.
Yes.
May I please, my lord? My lord, the application is praying for the scale-up pay associated with the post of principal. Your lordship issued notice on similar matter at item 12 yesterday.
Emergent notice. Mr. Behra, AG, learned AG, requested to accept notice for copies. 193. Right? Emergent notice to why that IAS officer is made a partial?
Because he has personally issued a letter which is in contempt.
OP number 2. The pendency of the petition shall not come in the way of jurisdictional OPs granting relief, granting redressal to the grievance of the petitioner. In every matter, you should bring this.
Yes.
Okay.
Right.
So that we can escape tax, the levy of heavy costs. Yes. Item 11.
Item 11 with regarding the petitioner is seeking increment, annual increment before completion of 1 year. The petitioner was retired. There is similar order passed by this.
Held that he is entered. The other court has held that he is entered. Mr. Behra.
My lord's representation is under Annex 5.
Consider that. Right?
My lord.
Say. If not this. All right. Item 12.
May I please?
Yes.
My lord, petitioner is a retired Hindi teacher since 31st July 2009, my lord. Pray before lordship to direct the opposite party number 3 to revise the pension and gratuity of the petitioner on the basis. My lord, one representation is pending before the OP number 3 since under Annex 10, my lord.
Mr. Behra will consider that.
My lord.
Petition prayer reads as that. Let me share with you. Counsel for the petitioner draws attention of the court to his client's representation dated 6/3/2025. A copy whereof is at Annexure 10. Wherein the last paragraph reads as a first. Counsel submits that the subject matter of the petition is similar to the one considered in WPC 26893 of 2020. Brother.
No, my lord.
Yes, you have mentioned that, na?
No, my lord.
Which is that judgment?
My lord, no, my lord.
You have mentioned that judgment.
In representation, my lord. No, my lord.
I'm reading that and I'm telling you. Otherwise, how I would know?
Item 12, my lord. Item 12.
Which is you have given to me. Yeah. Same case only. I'm reading from your Kalicharan, na?
Kalicharan.
Yeah, I'm reading from your representation.
Yes, my lord, my lord. Page 55, my lord.
54, 55. Submit that.
Yes, my lord. Yes, my lord. Page 55. Yes, my lord.
First one. Next parent. Not that AGA Mr. Behra, in his usual fairness, submits that he would instruct jurisdictional OP to take a call on the subject representation if all contentious are kept open and a reasonable period is prescribed. First one. This is appreciable. Next parent. 8 weeks. Okay. Reporting to compliance to the Registrar General of this court. That also. Delay is cost per day 500 rupees. The petitioner. That's very payable. I have made that one. Put it as a standard format. Yes.
OP number 3, my lord.
Yes. You should not ensure that delay is cost. To get the money cost. Yes.
Item 13, my regarding RSP matter, my lord.
RSP?
My lord.
Both the matters.
3 matters.
Yes, give that. This is the incomplete sentence. This is what I wanted. Just see this with okay, complete that sentence. I have given it also. Behra. Next. Item 14. Yes, sir.
This is the case, same case, my lord, Annex 17, page 80. Only separate petitions have been filed.
17?
Annex 17, page 80. Same case.
Brother Satpathy,
Yes. Same case notice has been issued.
No. We have issued notice in other matters.
This matter. Only as per the instruction of the court, I have filed separate petitions. Actually, 10 petitioners were there.
Take notice.
Only take.
Issue emergent notice. To Behra Ladniti accept notice for all the OPs. Matter lies in a narrow compass. Therefore, post it after 8 months. Okay.
16 also same.
Item also same.
16.
Along with.
Item 15. Lordship, item number 15 may be taken up 1 week after, Your Lordship.
1 week after?
Yes.
The matter, let us see.
Lordship, matter regarding to transfer, Your Lordship. But Your Lordship, in the meantime, there are some developments. The petitioner will give some instruction, Your Lordship, with regard to that, Your Lordship.
Wait, 2 weeks.
Grateful.
The request of counsel for the petitioner. Yes.
Item 17.
Yes, sister.
May I please, Your Lordships? In this case, my lord, my lord.
Bashing is 16/12/23.
My lord.
What is that?
My lord, in this case, my lord, the petitioner was working as a TGT, my lord, as teacher. So in the meantime, my lord, he just, without any show cause, he received annexation number 1, my lord, where he was put under suspension, my lord.
1 annual increment is withheld.
My lord.
Without cumulative effect.
My lord. My lord, he was not served with the show cause notice before.
Notice all you want to read.
Nothing, my lord. My lord, the reason is, my lord, paragraph 6.
Paragraph 6 of?
Petition, my lord. Petition, my lord.
Paragraph 6 of petition.
My lord, one Sanjay Samal, my lord, he was the headmaster there, my lord. He was in end of court, my lord, where he was trapped under vigilance case, my lord.
So false complaint and false newspaper report.
Everything, my lord, but there is the final report. Police investigated and found that this is false, my lord.
Emergent notice. Let's notice book.
My lord.
Mr. Mohanty, learned AG accepts notice for OPs.
Item 18.
Next.
Yes.
The petitioner is a retired employee, lecturer in English, and claims UGC scale of pay as has been granted in favor
Grant of UGC pay scale.
my lord. As has been
Where is
granted
your representation?
representation or annexure 3 page 13, my lord. That is
Who has to take the decision?
the director.
Director Higher Education, Annexure 3, at page 13.
Short grievance of the petitioner is reflected in the prayer form. First, counsel for the petitioner draws attention of the court to client's representation dated 6/5/2025, wherein the last paragraph reads as under. Next one, he submits that the officials are callous and they will not take any decision on the representations of the kind unless the court intervenes. First, he justified in saying this because this court is seeing hundreds of such cases every day, wasting a lot of public time because of the apathy of the bureaucracy. First, be that as it may. Next, the Mohanty he fairly agrees that he would instruct the OP number.
Opposite party number 2, my lord.
OP number 2 to take a decision on the subject representation if all contentions are kept open. First, he also requests that a short period may be, a reasonable period be prescribed for taking the decision. First, this is fair. Next paragraph. In the above circumstances, 8 weeks to take decision and inform the decision to the petitioner. 8 weeks it is. Open to solicit. Next. If delay is proved in taking the decision and informing, if delay is proved in complying with this direction, the OP number 2 shall pay rupees 500 to the petitioner every day from his pocket. And that shall not be charged to the public exchequer. All contentions kept open.
Item 19.
Published.
Registry to send a copy of this order to OP number 2 for his personal information and needful action, by speed post today. Yes. Yes, sir.
May I please your lordship? In this case, the petitioner filed the writ application challenging the transfer of the petitioner, Annexure 1.
That was in May. Transfer took place when? 1625.
October 2025.
October 25.
Page 12 Milo.
Page 12, Annexure 1.
What are the grounds?
Spousal ground.
Spousal ground.
Yes, my lord.
To take there is a appeal provided.
Yes, my lord. But representation is pending, my lord.
Representation is pending and therefore till consideration.
Yes, my lord.
Take any decision.
If not relieved, my lord. If not relieved.
If not.
Similar order has been granted by your lordship on 15th October, my lord.
By which order? Stay order. No, what I suggest is, we will direct the officer to dispose of your representations. Till disposal takes place, you will not be disturbed. But are you relieved from the petition now?
My lord.
Whether your client has been relieved from that post now?
No, my lord, he is on leave now.
He is on leave. The best way to avoid
medical leave.
My lord may say if not relieved, then it will suffer.
No. 10 days.
Because it is represented at 10.
He will write he has been relieved. He has no role to play.
If there will be communication, then it will be
correct. But the problem is, I have been seeing such matters, many such matters, where wherever you want, you will relieve them. Wherever you do not want, you have retained them for 5 months. Yesterday, I saw two cases. 5 months you have not retained.
My lord, it is different from case to case. But here, this person is continuing since 2006 on the date of his appointment.
So permanently, you want to be with the
in the meantime,
place.
It is his own admission, my lord. 6 to till 25.
You take decision on the
exactly.
The grievance of the petitioner is against the transfer order dated.
This is my lord dated 6th October 2025.
6/10/2025. A copy whereof avails at Annexure.
It is at Annexure 1.
Annexure 1. First one. Counsel for the petitioner submits that his client has already given a representation against the same in the light of Varadha Rao versus State of Karnataka. And till such a decision is taken thereon, the transfer should be interdicted. First one. He also tells that similar orders have been passed by this court in a spate of matters, which is stripped. Next paragraph. Learned AG, on request accepting notice for the OPs, submits that the jurisdictional officer shall take a call on the subject representation dated.
This is my lord dated 10/10/2025 under Annexure 3.
A copy whereof avails at Annexure 3. If all contentions are kept open and a reasonable period is allotted for that. First, with this proposal, counsel for the petitioner is agreeable. Next one. He further assures that, add one more thing. He further assures that petitioner would not be put to trouble if already not relieved pursuant to transfer order. This is fair and appreciable. Next one. With the above observations, petition is disposed of, fixing a period of 6 weeks for taking the decision and informing the same to the petitioner. First one. If no decision is taken in time, then delay shall attract the cost of ₹500 per day, personally payable to the petitioner from the pocket of by the who is that OP, district education officer concerned, from his pocket. The same shall not be charged on the public exchequer. Yes, everywhere you should put this question. Yeah.
It will be done, my lord. With the time.
No, there is no question. If you do, no question of payment. Why they should come before the court again? I am against that.
And this
will happen. This will change the pattern. You just see that.
We may not be misunderstood, my lord.
They tell them not to misunderstand. The government advocate shall not be misunderstood. Yeah. Item 21? 20. Yeah. 20.
My lord, in this case, my lord, the petitioner have prepared this writ application challenging the order dated 14/10.
It's the selection list.
My lord, that is open, my lord. They have not followed you.
Yesterday, it is in respect of the reservation.
Horizontal
Vertical and horizontal. Yesterday,
That
one
was
sir
reservation.
issued notice.
The requested WhatsApp notice. AGA. WhatsApp notice for OP numbers.
Here, my lord, where
Number
for the
3 to 7, my lord, private opposite party.
1 and 2.
1 and 2 only we can receive.
Emergent notice to the rest. Matter lies in a narrow compass and therefore the same be posted of 8 weeks.
My lord, now the 2000 posts are vacant, my lord. Your lordship may keep 15 posts.
What it says?
This is in respect of the
Any documentary proof?
Mark list.
Verification report. This is university matter.
My lords.
You take notice, emergent notice.
notice to be issued because fake some marks discrepancy in the marks which has been submitted by the petitioner concerned.
Go to first.
This is in a school, Milan. Private party is 7.
1 and 2.
I am for the 1 to 4.
1 to 4.
No, 3 is Sambalpur University.
1 to 4. Mr. Mohanty. Emergent notice to the rest. Yes.
My lords, not to further proceeding against it.
Any further proceedings are being taken now?
No taken, my lords.
This is a final order has been passed.
Final order has been passed on which day?
10/10/2025.
What is that? What it says actually?
The circumstance stated above the claim of the petitioner deserves merits no consideration and rejected.
What order, brother? What interim order you want at the hands of this court? Brother, I'm asking you, what interim order you want? It's a rejection order.
My lords, the petitioner allow the school and release.
Let us see. We'll call this matter after 2 weeks.
My lords.
All right.
My lords.
I'll call this matter after 2 weeks for consideration of the interim application. Okay. Next. Item 22.
It's a case wherein the prayer of the petitioner for grant for release of granting date has been rejected. In similar matters, in today also a matter was there at serial number 8, wherein a lordship was placed.
Number 8.
Yes, a lordship. Same matter.
OP number 3 is a private party.
Yes, a lordship.
Same one. Call along with WP number.
Yes.
This WP
Yes.
and serial number 8. Serial number 8.
Yes.
Okay.
Grateful, Lord.
Okay. Item 23. Yes.
May I please, your lords?
Yes, sir.
Lord, the petitioner has challenged the order passed by a state level scrutiny committee under Annexure 14 at page 86, my lord, wherein the learned SCLC has directed for an fresh inquiry headed by the local IIC when there is 3 inquiry report available in the case record by the district vigilance committee, so also by the Tahsildar, and another report by joint SDPO and Tahsildar, your lordship. But the learned SLSC misconceived this.
You take emergent notice?
Yes, your lordship.
Emergent. One day of notice. 1 to 8. Emergent notice to the rest. Yes.
My lord, I have filed an interim application.
We will consider it after service of notice.
my lord, in the meantime, if inquiry will be completed, then the matter become infructuous, your
An
lordship.
application includes seeking interdiction of the pending inquiry. First, counsel for the petitioner submits that the inquiry, if the inquiry is concluded during the pendency of the petition, the petition would be rendered in contempt. There is some ring of truth in this. First, with our circumstances, application having been favored, the inquiry is permitted to go on, but short of passing the final report. Then let inquiry go on.
Deeply obliged.
Report shall not.
Yes, lord. Deeply obliged.
Without leave of the court.
We'll say report shall not be acted upon. Inquiry report shall not be acted upon till the next date of hearing. Yes, Lord.
Item 24. May I please? In this case, petitioner seeking is antedate regularization, my lord. On completion of 6 years,
Dhananjay Charan,
it is covered by Dhananjay Charan. They made a repent.
Annexure 4 is there.
Petition, man.
Page 25.
petitioner prayer is held and first. Counsel for the petitioner draws attention of the court to the representation dated 5/5/2025 made by his client at Annexure 4 to the district education officer for consideration in the light of a coordinate bench decision. Is it DB decision or coordinate bench?
Coordinate single as well as division.
Dhananjay is
Single bench.
Decisions of this court quoted in the said representation. First, he submits that his client will be satisfied if a direction is issued to take a call on the said representation within a reasonable period. First, next paragraph. Counsel learned AGA Mr. Mohanty on request appearing for the OPs fairly agrees that the subject representation should meet its fate at the hands of OP number
3, man.
OP number 3 within 8 weeks. First time, to facilitate the sale, all contentions are kept out.
But this is OP number 4.
OP number 3. Jurisdictional rule. Jurisdictional rule. Okay? Ordered according to WP is this board of. First of. Then last paragraph. Dated 500 rupees. Put that. Yeah. Next.
Item 25.
May I please your lords? Here, my lords, petitioner is a graduate engineer, my lords. And I have also, my lord, page 32, lords, you kindly see. Here, my lords, in spite of his qualification, he is a BTech in mechanical engineer, MBA, OTET certificate, that teacher eligible test candidate. In spite of that, my lord, he has been given appointment under rehabilitation assistance scheme as a peon, my lord. When there are 700
notice.
Yeah, lords.
Emergent notice. Who has to give the appointment?
Opposite partner of 4, lordship. That annexure 19 has been issued.
The appointment order has been issued by.
Annexure 19 has been issued, saying that if you don't join in a group D post, then let's say page 102, millards.
But you should have been in which post?
Millards, in group C, millard, there are 741 vacancies, and rule says, the rule 1990 rule says that in deserving cases, can be group C or group D.
You take notice, brother. Or any representation is given?
No, let's say in annexure 19 has been passed on, yes.
Modified.
Yes, 8/10/2025.
Let us see. Let him take notice. Come back. Emergent notice. ASC accepts notice for OPs, all OPs. Matter lies in a narrow from first post week after 8 weeks. Okay.
Lords, IA is there, millards.
No, you will look that.
Lords, no, I have not joined, millards.
You join. Yeah. Petitioner is permitted to join to the post to which he has been appointed without prejudice to his contentions in the petition.
Grateful.
IA is for one.
Item 26.
In item 26, the petitioner and the candidates pursuant to an advertisement under Annexure 1 for the post of leave training reserve teachers 2024.
25, 31, 53.
Yes, Your Lordship.
These are the 3 questions.
Yes, Your Lordship.
Where is the typical answers?
Yes, Your Lordship. I have enclosed it under Annexure 12 series, Your Lordship, page 107.
Key answers.
Yes, Your Lordship. Prior to that, I can only show one thing, Your Lordship. At page 75, initially there was a final answer key to the model question paper which was put to us. Subsequently, the same was revised at page 77, Annexure 8. So what they have did, the OWC has did,
that for every wrong questions, they're given the grace mark. Your Lordship, page 77.
For every wrong question, they have given the
Grace mark, yes, Your Lordship. Page 77, serial number 15.
78,
77.
77, 78, 78 also.
Yes, Your Lordship. And in fact, at serial number 33, my lords,
Take notice. Issue emergency notice, safe production.
statement.
AAC requested to accept notice for one. The staff selection panel.
Commission is there's a panel council, Your Lordship, but there are multiple councils. So I'll take notice.
Issue emergent notice to voting number 2. But in addition to taking usual steps, petitioner may serve a copy of the petition along with all the documents on any of the panel council ordinarily representing the OP number 2. Now, any interim prayer you have made? No.
No, Your Lordship, because why I didn't do so? In similar petition, Your Lordship already stated the operation, so I didn't find it necessary. I'm grateful.
Next. 27?
In both the cases, Your Lordship, same.
No. Follow on.
May I please, Your Lordship?
Yes. 28?
Item number 27.
27.
My lords.
27. Just mark in your published. So
Your Lordship, as many as 9 teachers are before Your Lordship. Now their salaries have been withheld from the last 5 months. Without according any reasons, no notice has been given to them as to why the salary has been withheld.
Why only? Take notice.
Annex 2 is my representation, my lords, which is lying before them, and for 5 months the area is still pending.
Rest of the salary is paid now.
No, nothing has been paid for the last 5 months, and they're still continuing. Currently, I believe it is 6 months now.
If direction is given for consideration of representation with a clause of making payment,
my lords, I'll be grateful if that is there.
Short grievance of the petitioner is as to withholding of payment of salary for certain months, sans any reason. First, counsel for the petitioner draws attention of the court to his client's common representation dated
3/10/2025, page number 41.
3/10/2025, wherein the request is made for release the payment of withheld salary. First one, counsel submits that if a decision is taken by the jurisdictional authority OP on the said representation, his clients would be satisfied. First, he also tells the court that withholding of salary is a draconian action when in these costly days. First, next paragraph. Learned agency on request, you will instruct your officer appearing for the OPs. All OPs.
All OP.
Agrees with the suggestion of this court that decision has to be taken on the subject representation within a reasonable period. First one. He tells the court to keep open all contention. First. Next class. In the above circumstances, petition is disposed of. 4 weeks.
Lordship.
Within 4 weeks.
May I play one that annex to that representation is an advocate notice, my lord.
It is fine. For notice also you are not responding. It is worse.
That I have to.
Minutes may see my representation. It comes with a schedule, my lord.
They don't care now. Your clients we know, your officers I know. They don't care citizens. Yes. 8 weeks. The decision taken to be informed to the petitioners within the said period, during which the delay will carry a levy of ₹500 payable by OP number.
Your Lordship, 1.
OP number 1.
Yes. One is the principal secretary, my lord. The district education officer.
OP number 4.
4 minutes. Sorry, I stand corrected minutes.
OP number 4. ₹500 payable to each of the petitioners by OP number 4 per day of delay from his pocket. First off, the same shall not be charged on the public exchequer.
It's just one line, if your lordship may I suggest. Let them consider payment of my area salaries, your lordship. That is just something.
No, your representation you have made.
My lords.
That whatever is there, we can order. There are other things we cannot order.
Grateful, your lordship.
In the first paragraph, what you written? costly days, I said, na? In these costly days, it said that. In these costly days, first off, he adds that there is absolutely no reason for not paying the arrears of salary. Okay, that sentence you read.
Gratefully, Lordship.
Next, item 28.
Please, Your Lordship. Here, my Lord, I had filed a writ application. In the meantime, some development has taken place. So I want to
withdraw the petition.
Withdraw the petition with the liberty to file a better application, annexing that development.
Petitioner has moved a memo dated so and so. It reads that. Do you have objection for giving no notice is issued as a
No, my Lord. Yes,
ma'am. In terms of memo, petition is disposed of as a routine withdrawn with liberty as sought for. Item 29.
29, my Lord. Here is the petitioner who is working as a cook, my Lord, in the midday meal center, my Lord. Cook. Cook, my Lord. For last 15 years, my Lord. Now she is 57 years, 55 years old lady, my Lord. By the annex 2, my Lord, all of a sudden the OP number 5 has issued the letter that from tomorrow onwards, that 30th of
Don't come tomorrow onwards, we will not cook any food at all.
No, my Lord. Your services are no more required.
But how they are cooking? Whether the same OP will cook the food?
No, the background of the case is below in the letter.
How long she was cooking there?
Last 15 years.
15 years?
15 years.
Brother, yeah, if you send her home, what she should do? 15 years she has cooked food for you.
That is not there. Only the notice issued by the headmaster, that is the only.
They're all poor people.
What's she?
You continue what? Otherwise, she will put arsenic in the food. Some poison she will put. What will you do? Continue in the office. Okay? Otherwise, they will lose faith in the judiciary. She is a cook. 15 years she has cooked the food. All of a sudden, if you send her home, where should she?
Allegation is that it reflects from
there is discrepancy in the date of birth.
Date of birth. Whether cooking is affected by that.
No more.
Not that.
Issue emergent notice. First, petitioners, any application you moved, brother? Any IA? Petitioner has moved application in IA number 18717 of 2025, seeking interim protection on the ground that she has been working since last 15 years with no complaint whatsoever, and therefore on an unfounded allegation come up, her services could not have been dispensed with. First off, he also tells that the job is the only source of livelihood, and therefore, if that is snatched away, that amounts to taking away the means of livelihood, which is contrary to decision of the apex court in Olga Tellis versus, take out that judgment, versus so and so. So there is, of course, in this submission, that in the above circumstances, application having been favored, who has to continue you? Which respondent? Which OP?
5 million.
OP number 5 is hereby strictly directed to continue the petitioner in the service with the same terms and conditions as were applicable to her position during the pendency of the petition. First off, the compliance of this interim order should be reported on the next date of hearing. Call this matter on 18/11 for reporting compliance.
Let's say one thing. They have said in that letter that from tomorrow, 30th of October.
No, it is being questioned. This is for complying. Whether they have taken you or not, they have to inform the court. If I send money order, I should know whether my money has reached it or not. That kind of order it is.
Only
in your favor.
Only I pay like my law firm may intimate the OP number 5 that this order has been passed to
acted upon.
Grateful.
Yes, immediately.
May I please, my lords, the transfer matter, my lord. Annexure 5(3) has been issued by the opinion number 3 to account of opposite partner 5 in that particular school, my lord. Opposite partner 4, 5, but declared 4 times in 6 months within the cut of full town, in different schools, my lord. Because he was posted to a rural area. You know, accommodate her in different schools as an orders in place. Ultimately, annexure 3 is issued by opposite partner number 3 and posting
Rationalization basis.
but the allegation is that in not account of 5 in the particular school in Puri town, he was posted in rural area. In account of Puri town, my lord, 4 transfer is issued within 6 months by the opposite partner 3 in favor of opinion 5 on the plea of representation. And ultimately, I have been disturbed. May I will file a representation of the opinion number 3, opinion number 2, director. That is the issue.
You have not given the representation.
I am not given. Because eagerly I have not.
Grievance of the petitioner is against the transfer order dated 23/7/2025, copy whereof awaits a connected Counsel for the petitioner submits that the transfer is mala fide and therefore is liable to be voided in the light of decision of the apex court in Shilpi Bose versus so and so. Because that just not Because something, you know? Yes, you cannot transfer somebody to accommodate some other person. First. Next paragraph. Learned DSC on request accepting notice for the OPs, except numbers 1 to 4, opposes the petition containing that petitioner has got an alternate remedy of making representation to the concerned officer in the light of decision of the apex court in Varadhara versus state of Karnataka. And therefore he should be relegated to the scene. He or she might be relegated to the scene. First, there is force in this submission. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation to the jurisdictional OP number 2. And if one is made in 2 weeks, the same shall be considered within 3 weeks next following. First up, open to solicit. Yes.
I am still continuing. I have not relieved, my lord. I am not allowed to continue. I have not relieved it.
Till to facilitate, to fructify the disorder, petitioner is directed to be continued. In the same place, unless she has already been. Yes, that's all right. Item 31. Yeah.
Yes, the professor, my lord, of the Odisha Agriculture University is qualified, sir, for some period of service where we were sent for the work in KVK, that is Krishi Vigyan Kendra under the OUT, has not been calculated for the purpose of
what the document 6/12/24 says, so it discounts that period.
Yes, that is why my lord have already held in that writ appeal I have filed in division bench where my lord was presiding over. They are also held that. But
they were
was appearing.
Not part of the university, this, that, etc.
Yes. My friend is there, I will serve a copy.
Notice.
Yes, ma'am.
I will give it.
Issue emergent notice. Learned panel counsel on request and subs notice for
2 to 4.
ASC
I am for 1. Yes.
Matter lies in a narrow compass. First, counsel submits that it is covered by decision of freedom, then by decision of this court.
Yes. In Manoj Rauter, WA number 6, I have given it. 675 of 24. My lord, sir.
In writ appeal number slide. So write down and give that.
It is there, my lord, page 20. Writ appeal 675.
This matter on 27th of November.
27th, I will have said 28th.
28th. In the meanwhile, it is open to the office to file objections if any. Counter if any. Okay. Next.
Yeah. On the recommendation of a ML and MP my lord, and notification of 3 my lord, the opinion of 3 has to transfer to the petitioner to another place. Similar matter my lord has passed.
But where is that The order speaks, my lord. There is no
Annexure 3.
Annexure 3 is a notification, all right, but the transfer was made by the transfer was made by the district level transfer committee.
Annexure
But
2.
committee comprises of an MLA.
No. It is there. Committee he is a member there.
He cannot. He will file the university, the educational institution.
My lord, I'll file a counter to this case.
Grant of it. Same order. We are giving interim leave. The MLA has no business to enter the classroom, educational matters. Yes. They will spoil it. Yes.
This is the same case, my lord. It is the same case, my lord. It is unfortunate that the recommendation has been made by the MLA.
No. There is no recommendation at all.
What we order it like this?
No.
Annexure 1, page 8.
No, I have given interim order to you. What to you?
That case.
Your matter also.
It's also same.
Which one?
Next matter, 33.
33. Same order. Just see the date of the date of that.
District level transfer committee to the MLA
9.
The impugned order of suspension was before Lordship, and before Lordship interfered in this matter and directed the DO to compliance the report of the reprint in the light of the judgment Ajay Kumar Chaudhary versus Union of India in the Annexure 6. Thereafter, DO already held and directed the BO Lordship, last part, your Lordship, page 27. There is the to reinstate the service of the directed to BO. To reinstate of service, last part, your Lordship may see. That is in a view, page 27, but not. Yes.
Look at it.
Yes.
I wish it will be
my lord.
But I want to use the word.
My lord.
To look at the judgment.
Yes.
To whom you want to communicate. You have to ensure whether he is receiving it or not.
Now, I have communicated to...
No, to me.
Yes. Yes, my lord.
To me. Perhaps the same way you have communicated to him. Therefore, he has not done it.
Yes. The regional lordship see page 27.
Can I, my lord, address? Lordship, may kindly have a look to page 26, Annexure 7, last paragraph of the impugned order.
Block education.
Yes. What is I reported that Sanjay Kumar Jana, the petitioner, has committed a lot of irregularities in maintenance of school records and irregularities in school duties. He has been frequently visiting the BO block education office without any valid reason. And also, this is important, my lord, in drunken state and loiters in the office premises and here and there. He was also involved in Badasai PS case number so and so in offense 147, 148, 341, 294, 283, so many offenses, prevention of damage to the public property, etc.
But hold inquiry. I agree with you.
My lord.
You hold. You
no, my lord, wrong submission. Your lordship's gone to page 30. Page 30. Page 30, my lord. For a moment. To page 30. There is
the impugned order itself.
Yes, no. Your lordship, see page 30. There is the he has
nothing adverse was found against him or her in the records of the aforesaid police.
Yes. This is the impugned order, my lord.
That's all right. But the police himself, the character certificate has been issued now.
There is no antecedent. My lord, there is no antecedent.
Let us see. It's not that simple. Let us see.
Only 7
emergent notice.
7 months, my lord, only service.
Notice for 1, 2, 3, 4.
My lord, only 7 months left in the service. And we
got this matter on 28.
28. 28.
Yes. Mr. G, see that character certificate.
Yes.
These people give character certificate, I do not understand.
DIP. There is no antecedent. During this period, they wrongly submitted, wrongly stated my lord the PS case. Your lordship see, this is a certified. That is the.
No. Item 35? Yes, sir.
Matter of transfer on the basis of that MPM recommendation.
MPM matter. You give no is granted. Whether you have been relieved from the
it is said that today or tomorrow they will relieve me.
Is it? Yes. Today only I will pass order then.
Yes.
Yes. issue emergent notice. Mr. G accepts notice for 1, 2, 3 and 5. Emergent notice to both.
OP number 3, Miller.
OP number emergent notice should be to 4, na?
3, Miller.
So no.
Notice OP, the private party is 4.
5 by Mr. G. And 4 emergent notice. Petitioner has filed an application in IN number 7 for seeking interim protection against the transfer order dated
23/10/25 under Annexure 6.
Annexure 6. First, he submits that in similar matters, interim protection has been accorded, and therefore his client should not be discriminated against. First, there is force in this submission. Next one, in the above circumstances, application having been favored, the impute transfer order is hereby stayed, coupled with a direction to OP number
3, Miller.
3 to continue the petitioner in the same force and place wherein he or she, wherein she was working before the issuance of transfer order, unless she has already been relieved from the said post. Web copy to be acted upon. Call along with WP number. Which is that other WPs? Do we have copy? Connected matters? Right. Call along with such. Yes.
Item 36.
Relating to RSCP Lordship, the events of the petition has been forwarded by the District Education Officer Ganjam to the Director Secondary Education Orissa. Lordship directed to the Director to consider the forwarding report by the Annexure 6 on page 18. Lordship.
RSCP.
Lordship.
Annexure 6.
Running page 1.
Or
impugned order it is. Requires a hearing.
Yes.
We can't just consider it will not help you.
No, Lordship, can I ask the last portion of the running page 19 of the same order? Therefore, necessary instruction may kindly be issued regarding sanction of
RSCP in favor of Sri Indian Kumar Sahu.
Lordship.
The important WP so it supports your view.
Lordship.
Mr. G, it is not rejection.
My Lord, the Director Secondary Education.
Yes. The short grievance of the petitioner is as to non-sanctioning of RSCP benefit under RSC. No, RSCP benefit. Counsel for the petitioner submits that there is a recommendation by the District Education Officer by the endorsement dated 17/9/2024, a copy whereof avails at Annexure 6. And a representation is also made by his client on where is that representation? Representation is also made. In the light of a decision of coordinate bench of this court in WPC 16175 of 2024 between Ranjan Kumar Sahu versus State and others. First off, he adds that his client would be satisfied if a direction is issued to consider her request, his or her request, in the light of recommendation made by the District Education Officer. First off, next paragraph. Mr. G, on request of AGA appearing for OP, submits that he would ensure that the subject representation shall meet its fate at the hands of who should take the decision? Director Secondary number 2. If all contentions are kept open and a reasonable period is granted. First off, this is appreciable. Next paragraph. That was a 8 weeks. Okay. If delay is caused, delay is brooked in complying with this order, OP number 2 shall pay rupees 500 rupees per 200 rupees per day to the petitioner from his own pocket. And that the same shall not be charged to the public exchequer. Not all contentions can. Yeah.
Item 37.
Well, yeah, this petitioner is an employee of the Board of Secondary Education Odisha. Was an employee, sorry man, retired. My lord, he was allowed to serve up to 60 years of age, but they have been paid the pension by calculating the services up to 58 years. And this issue was fought in this Hon'Ble Court, went up to Supreme Court, and it is upheld that they will get all the benefits up to 60 years of age.
One period of service should be.
Yes, should be counted for the purpose of pension.
Notice.
And my lord, these order, similar orders here, because that was pending in the Supreme Court, they have rejected it once in Annexure 4.
Correct. But let them come again. Otherwise, if I say
yes.
representation, again it will be.
The similar order have also been passed, but that has to be quashed in the presence of Mr.
For question, they have to be heard.
I will give a they will not appear. Mr. S.S. Rao, senior advocate, I will suggest. I will give a copy next week or any time. It will display.
Senior panel, Mr. S.S. Rao is requested to accept notice for OP 1 and 2.
My lord.
OP 2 or OP 1 and 2?
My lord,
no,
both, my lord. Yes, for the Board of State, the written counsel.
Petitioner to serve copy of the petition along with all the documents on the said petition. Say, okay, immediately. First matter lies in a short compass. Call this the first week of December. Right. Yeah.
Item 38. May I please, Madam?
38 sole prayer.
And the affidavit filed before me by this Honorable Court as per the directive.
You have cows and other.
My lord. Milk selling business since 2023 continued by her after COVID-19 due to loss her business, and she have 5 cows and 2 goats. All this information through this affidavit filed before me by this Honorable Court by the deponent.
The sole prayer is to consider the representation by the person.
They are not considered the same since.
Let them consider.
My lord.
In the light of short grievance of the petitioner, regardless of the textual prayer in the petition, is against non-consideration of the representation
Dated 18/7/2025.
18/7/2025, a copy whereof avails at Annexure.
Annexure 1.
Annexure 1. First time. For ease of understanding the grievance, the entire representation is reproduced.
Before opposite party number 2, Tahsildar Bargat.
First. Next one. Learned counsel for the petitioner submits that if a direction is issued to OP number 2 to consider the subject representation, his client should be satisfied. First one. Mr. G agrees with this submission in his usual fairness, provided that all contentions are kept on kept open. First one. In the above circumstances, petition is disposed of 8 weeks. All contentions are kept open.
My lord, may kindly consider within a stipulated time.
8 weeks.
8 weeks.
8 weeks.
Much obliged.
This separate may not be necessary. Just I want it. It only reflects your ingenuity as a lawyer.
My lord, that's why I
with the lawyer. Yes,
that's why I filed affidavit before this a lot.
There is 39?
39
My lord, kept on record this affidavit may cannot.
No.
Affidavit by the
sir.
No, sir, था आपनको पाके देई कोर्ट.
अरे सर कोर्टिंग देना दरकार नहीं.
We have given the relief only to you. Whatever praise they have made, what is that?
My lord.
Because your client may mistake you. You have taken it and you have not filed it that way. But in the order sheet, affidavit filed by the petitioners pursuant to order dated.
Previous.
Yeah.
To the order.
Let's look into that.
Dated 27/10/2025.
Is taken on, accepted on record.
Much obliged.
Next. You want to withdraw the petition? My petition will be disposed of as having been withdrawn. Yes. Register to send a copy of this order to the office. Let's be posted. Private office. If any private office are there?
No, ma'am.
No private office? No. G accepts notice for first line. This code of affairs have been withdrawn. Next. Item 40. Yes, sir.
My lord, the land was allotted under Annexure 1 since 2005, my lord. As per the said letter, I have deposited the entire money, my lord. IDCO. Page 7.
Possession is not given.
Possession was given.
Given to you.
Yes, my lord.
Now disturbing.
Yes, my lord.
What they are doing?
They are going to give one escape polytechnic over that. Then I approached the authority under RTA, Lakshmi C. In RTA Act, they said the following information, Lakshmi C, IA, page 5.
Emergent notice from?
Jaitra Hajur, a lot notice already that. Instruction.
Government come down. Who appears for the OPs?
All Lordship may direct the Principal Secretary against whom my representation is pending. He can decide on merit. You
will be satisfied with that?
Yes.
Petition prayer reads as that. First, counsel for the petitioner draws attention of the court to the representation dated
14/11/2024.
14/11/2024. It is appeal. Appeal or representation?
Representation.
14/11.
With regard to dispute of that.
At Annexure 2, addressed to the Principal Secretary, Industry Department of the government. First off, the representation reads as that. Next paragraph. Counsel for the petitioner submits that if a call is taken on the subject representation on merits, within a reasonable period, his client will be satisfied. Who is Mr. G?
Well, IDCO is the answering.
The Principal Secretary of the government has to take the case.
IDCO, it is under station.
No, correct. But the Principal Secretary happens to be decision maker under that particular scheme.
Normally, I appear for IDCO. Here, what I find in the note my friend pointed out that copy not served. Perhaps it was directed that to serve.
You copy.
I will give the copy.
You consider the representation. That's all.
The representation, the industry secretary is nobody.
Who should consider?
IDCO.
You will consider.
MD IDCO. What my lord, senior in committee?
Chairman from.
No, but the IDCO is a party. MD is party.
MD is a party or not?
MD has to take the decision, madam.
MD. MD is a party.
Let him take a decision.
Number 2. What is the what is happening? Let me first
give that copy. I'll call this next week. Yes, let him look into.
Next week, 1 week.
2 weeks.
Let me fix up the note so that
Shri. Appears for the no, some advocate on record, you cannot take notice.
Son.
The advocate on record can take notice.
Yes, Pranay Manti.
Mr. Learned panel person is requested to accept notice for OP numbers from the 234. 234. Behera for one. Better lies in a narrow compass. Call after 2 weeks. Give copy.
Yes, my lord. Already.
Yeah. Item 41.
Yeah, beautiful.
Item 41. 41.
Please, Lordship. I have no matter on behalf of SN Patnaik for staff selection comes.
But you appear for
OP3. On behalf of staff SN Patnaik for.
You want to write? What you want to say? You don't want to say anything.
There is a noting petitioner file a IF or withdrawal, my lord.
Is it?
There is a memo for the affidavit.
Petitioner seeks leave of the court to withdraw the petition. First off, the affidavit seeking leave for withdrawal reads as that. Next paragraph. Petition is this court of affairs has been withdrawn in terms of the affidavit. Item 40. I'll come back within a couple of seconds.
Item 42, a rejoinder is filed, but copy not served on us.
You copy.
I'll serve it another.
We'll have it in the first week of December.
November.
All right for you also. Your opinion? No.
November.
November we have difficulty. We have loaded the calendar with too much weight now.
As a lordship pleases.
First week of December. First week of December. In the mean, we'll copy. You sir, copy.
I'll do it.
That's the request. Yes. Item 43. 43.
Already in item 43.
Yes.
Your Lordship may kindly see the order dated 25/7/2025. Your Lordship state the transfer order. Transfer order shall not be given effect to. Despite that, the district education officer is not permitting the petitioner to work. I have filed one IA. Well, copy of the IA may be served.
Already, sir.
It is noting is there, copy not. Noting is there, but this is the receipt.
One more copy.
Yes, I will give one. I'll take instruction.
Call up the 2 weeks. At the request of committee to come back with the one first if complaint of the petitioner as to non-compliance of the interim order is found to be serious consequences will fall on the head of answering both the
interim order to continue.
Interim order to continue.
Copy in course of matter.
Yeah. Ask them to comply with the order.
My lord.
Court order should be respected by everybody.
My lord.
44?
34 also, my lord. This one is there. You call it 2 days after. I have called the officer today.
Right.
Pardon, madam. We need to fix, madam. We need to fix, madam.
2 days.
Monday, your lordship may call.
I am likely to be.
Yes, my lord. There is holiday.
Issue. We'll call this matter on 10th.
Madam.
10th.
It will be complied.
He says he assures that it will be complied.
Yes, yes.
Yes. Item 45? Yes.
Yes. My lord, here, a plot was allotted to the petitioner for building a hotel.
Who appears for the other side?
My lords, my learned senior.
Are you ready in the matter? After the hearing, I will not give time.
That is right. We have given the counter. Reason is there in the impugned order.
No. I am asking you, are you ready in the matter?
Yes.
Yes. But once the argument begins, then no time will be granted to anybody. Yes.
My lord, here, a plot of land was allotted to the petitioner for constructing a hotel, my lords. Now, suddenly this proposal without any show cause to us, without any rhyme or reason was withdrawn, my lords. So I challenged it before this honorable court. The land allotment is to be done by ITCO. Now, your lordships may kindly see 110, which is your lordship's order. This honorable court's order, I'm sorry. In the rejoinder, my lords. I have annexed the order of this honorable court.
This is essentially dispute relates to cancellation of allotment.
Yes, my lords. And ITCO agreed before this honorable court, if I pay the market rate, then the land will be allotted to me as per a circular of this of the state government, my lords. Your lordships may kindly see.
And you have paid the money also.
We have made an offer to pay the money, but they again cancelled it on the ground, saying that there is a case pending before NGT, which has subsequently been dropped. And secondly, they say that in 2018, a circular has come about wherein it has been decided
that lands are to be allotted on an auction basis. Now, my lands were allotted in 2010, and that circular was very much present with them when they agreed before this honorable court in 2019.
So subsequent circular cannot alter the position.
Exactly, Mala. That is my case. Your lordships may kindly just see page 110.
110.
110. That is rejoinder, page 15. The petitioner wanted to open a hotel. The DIC and the tourism department opined favorably in favor of opening of a hotel by the petitioner. The petitioner thereafter, along with recommendations of the DIC and the tourism department, applied for a piece of land from the ITCO. ITCO in principle agreed to provide a piece of land to the petitioner along with schedule of property wide Annexure 3. However, in a high level meeting under the chairmanship of Chief Secretary Odisha held on 3/4/12, it was decided to reject the proposal in favor of the petitioner and to withdraw the in principle letter issued in favor of the petitioner. The petitioner is aggrieved by the aforesaid letter. Mr. Mukherjee, learned counsel for the ITCO, with his usual fairness, submits ITCO has no problem in allotting the plot to the petitioner for opening of a hotel if he agrees to pay present market rate. The high-level committee took a decision on 3/4/2012 in view of the principle decided by the government wide notification dated 12/4/2010 in Annexure V/2 to the counter affidavit, wherein it has been decided that the government land in Bhubaneswar Municipal Corporation area will not be allotted to the industrial units at a concessional rate. Regard being had to the facts and submissions, the writ application is disposed of, directing petitioner to file a detailed representation before CMD ITCO, making an offer to take a piece of land for opening of the hotel by paying the present market value of the same. If such an offer is made by the petitioner, the same shall be considered and disposed of with promptitude within a period of 2 months from the date of application, giving preference to the petitioner to allot land at a place where hotel business shall be conducive. If the particular plot wide Annexure 3 is available, this allotment of the same in favor of the petitioner may also be considered. So this plot is still available.
Maybe considered.
It shall be considered. Correct. And they have agreed if I pay the market rate, they will allot the plat. They will consider mine. Yes, my lords. I made this application offering to pay the market rate. They reject it on 2 grounds. One is, my lords, pendency of the NGT case.
That has been dropped.
That has been dropped, my lords.
As on the date they rejected whether it was pending or not.
It was pending.
But later, subsequently
it has been dropped. And on top of that, my lords, during the pendency of the NGT case also, we have brought out the information under RTI. My lords, they have allotted other plots for hotel to other units, my lords. Not to us, my lords. This is one point.
On what terms?
My lords?
On what terms?
Same terms, my lords. Market price.
Market price.
Yes, my lords. And the second point that they have raised is, in 2018, a circular came, my lords, that lands in Bhubaneswar Municipal Corporation area for hotels will be auctioned. That is in 2018. It cannot have a retrospective effect to 2010 when the land was first allotted to.
No, its policy changed.
Policy has changed. And 2018, my lords, my lords, before this honorable court, they relied on the policy of the government saying that I will pay the amounts as per market valuation of that particular area. So 2000, they never relied on the circular or never took a stand at that point of time, my lords. So now, my lords, taking such a stand again, once they agree before this honorable court, it becomes unfair, my lords. And, my lords, it's also in a way barred by constructive res judicata, my lords. They could have taken this point also, my lords.
Now, how they will know? The one fine day, the government will issue another circular policy.
2018, the policy circular has come, my lords. So they must be aware of it. This order has been passed in 2019. 9/4/2019. This circular was in 2000. And my lords, they, with proper instructions, they have, my lords, agreed before this honorable court that this plot is to be allotted to us. That is my entire case.
Your first ground is just articulate right now.
My lords, my first ground is, my lords,
yes,
that My lords, this, I'll just point out from on the date the order was passed, my lord, they agreed before this honorable court.
No, give dictation.
My lordships.
That particularly, it becomes easy for me.
My lords, my first point is, my lords, there being an agreement before this honorable court that the land would be allotted to me at market price. Now they cannot wriggle out of this agreement by taking us.
Where is that? Land will be allotted. Land will, your request for allotment would be considered.
Yes, my lords. No problem in allotting a plot to the petitioner. They said there will be no problem, my lords. The wordings, the import of the wordings are to be taken as a whole, my lords. They will have no problems in allotting the plot to me if he agrees to pay present market rate, my lords. And my lords, and they also rely on the proceedings of the high level committee in view of the principle decided by the government, wide notification dated 12/4/2000 to the counter affidavit, wherein it has been decided that the government land in Bhubaneswar municipal corporation area will not be allotted to industrial units at a concessional rate. So they rely on this circular. Whether it is open to them now to rely on another circular, which has anyway come in 2018. Now,
whether this circular was
one
second, yes, whether that circular supersedes this circular, show
that my lords,
that will decide your rights.
My lords, that's a subsequent. Then I'll have to see that.
This is superseded as on the date the order was made.
Yeah, yes, my lord.
Then this is an order which ignores the policy of the state. That will not operate as a judicate now.
No.
There are such judgments. Now see that one. Let us read that 2018 circular.
Yes. That is at page 82. 82A. 82A, Annex 6.
This is resolution.
Yes, sir. In order to promote tourism and a mission mode for economic development and to promote the brand image of Odisha nationally and internationally, also to direct initiation, the government 82. Next page. The above guidelines shall, if your lordship kindly turns to 82B, man.
82B.
Yes, man. The above guidelines shall not be applicable for municipal corporation area limits of Bhubaneswar.
That's all. That is now which is not available is not applicable to you.
Yes, man. Brahmapur, Raurkela and Sambalpur and municipal areas of Puri. For these places, an auction method shall be followed, the norms of which shall be fixed by tourism department. This is what they say.
You say 2015 circular, na?
I said 2018. This is a circular of 2018.
You were banking upon 2015 circular. But that has been acted upon by the government.
2010, which is reflected in the order.
Where is that 2010 circular?
It is their internal, it is their circular, government circular, which they have relied upon.
No, you are using the word circular.
Yes,
the words used is resolution. Courts have differentiated between the resolution.
Yes,
passed in executive power.
It's a notification dated 12/4/2010 in annex
publication. It's a resolution of the government.
This
that comes to you, your help.
Yes, ma'am.
Terminology.
Yes,
come to your help.
This is a resolution. And my lords, that counter, Annexure B/2 of that counter, they have relied on this notification.
2010 notification.
Yes, well, Annexure B/2 of the previous.
Where is that?
Yes, ma'am. My lords, your lordships may kindly say running page 57.
57.
It's a part of Annexure 1. It's a part of Annexure 1, my lords. The rate and copy counter copies in the first rate application.
Running page 57.
Running page 57.
This is a
Notification.
Notification dated 12/4/2010.
Under what, in what authority this has been issued?
This is the industry department issuing the notification.
Under which law?
Under my lords, they issue these notification relating to land allotment by powers vested to them under the, my lords, land development authorities, my lords, like GA.
Under which law?
My lords, the law. This is the general law of the statute. My lords. It is not reflected here, my lords.
That's what. And the second one, resolution.
Which one, my lords?
The 2018 resolution.
This is the policy of the government.
No, I'm asking.
Yes, sir.
2018 resolution. It is under which statute?
This is a resolution by the Revenue and Disaster Management Department in order to promote tourism in a mission.
It's perhaps an exercise of executive power.
Yes, executive powers. It's in pursuance of executive powers.
So you have three contentions now. Number one, battle lines were drawn up in the earlier litigation.
Yes.
And as per that, they are bound to pay the land at the market price.
Market price.
Number two, they cannot rely upon 2018 resolution because case was decided in 2019 and 18 was already available to them. But they backed upon 2010.
Yes.
Number three, you said 3 points.
Similarly placed hotels.
Others they have given.
They have been given this these.
During what period they have given?
They have been allotted, my lords.
Was it before the 2018 resolution or after?
Page 45.
Page 45. Page 45, my lords. If your lordship sees kindly sees page 45, statement on allotment of land at Chandka Industrial Area. This is within Chandka Industrial Area.
Much before 2018.
This is 2010. They have date of allotment.
Yes. When the earlier notification was, the circular was holding the, it's not even circular, government order was, notification was holding the.
Yes, my lords. 18/3/2010, Krishna Palace, Hotel Navayug.
So all are before 2018.
Yes, my lords, 2010. My allotment was also during this period, but strangely enough, they decided to go back on the allotment. And then they came before this honorable court and said,
let us see what they say.
Yes.
Yes, sir.
My lord.
Lord, INCO, it is called the Orissa Industrial Infrastructure Development Corporation, which is a government of Orissa undertaking that is.
It's a government company as defined under 617 of the Companies Act 1956.
That is under the IDCO Act.
This is a separate act. It's a statutory corporation.
Yes, IDCO Act. So it does not have its own land. What it does, the government, supposing the industrial area will be developed, then the government makes the requisition, and that is, yes, IDCO makes the requisition, and then the
government allots it.
Land Acquisition Act they follow, acquire the land, then they give the land to the IDCO. The IDCO in turn deposit the money, and land is also provided for the industrial development industrial purpose. That is, the industrial estate is there. Other is, supposing somebody wants to have an industry in a particular area, then in that land, it is, first of all, find out whether it is feasible or not. Then also government is requested to make the acquisition of the land. So,
where is the policy of allotment of land by IDCO? What policy IDCO follows?
IDCO follows, Miller, that is.
Where is that?
That is under the provisions of the IDCO Act.
Yeah, I want to know.
Act is.
We have submitted a copy.
We had submitted a copy, lordship.
And these are the rules for your lordships.
Which are the rules, sir? IDCO is not a dalal. It's a statutory corporation.
Right.
Therefore, the conditions that will be available to a private dalal will not be available to you.
Sure.
This is number first limitation.
Yes.
Yeah. Then, since it's a statutory corporation, the action should be reasonable and it should be on normative basis.
Yes.
These are the two requirements. Yes. Which are the rules which provide for allotment, etc.?
That is under the Act.
Which section?
Section 15.
1.5. Please read.
Subject to the provisions of this Act, the corporation shall have the power to acquire and hold such property, both movable and immovable, as the corporation made necessary for the performance of any of its activities, and lease,
Shall exchange or otherwise transfer any property held by it on such conditions as may be deemed proper by the corporation. Then the government has no role to play.
The government is only to provide the land.
But they have issued a notification how land should be allotted.
That is subject to government policy. Here, what my learned friend says, let me clarify. There has been absolutely no allotment, final allotment. What it was decided, it was intimated that it has been decided to allot the land. But subsequently, what happens after the allotment is made, subject to terms and conditions, then it is followed with the execution of a lease. And that lease is also not permanent because always the lesser right is there. Then in between what happened, what is saying that hotels have been given, it is not correct. That is only in the month of November 18 that happened, and that the final allotment had not been given, and you will also will find from the impugned order what, and also the order of the Honorable Court, nowhere it is agreed by the IDCO that if the market rate is given, we are ready to give. Nowhere it is stated. That is not there. So that is why he opted to make a representation for consideration, because while it was withdrawn. Then that is the comprehensive order is there, your lordship kindly find. I am just reading out.
No, first contention is a bit different. You are mixing them. First contention is it was agreed to allot, but allotment was not done.
Not
done. So you had agreed to allot.
Yes.
Once you agree, can you go back from your agreement?
Because until you have given a final allotment.
No, I'll come to that.
Yes.
The contract does not come into force, is true.
Right.
But in public law, if you agree to give, you are bound to give.
Let me clarify myself.
Yeah.
So your lordship to that documents. The Annexure 3, page 34.
So the first one is you have power to allot.
Right.
Section 15 of IDCO Act. No, this is some act. This is right of this one, 1980 Act. Gives power to IDCO to allot any of its properties by way of lease, sell, perhaps sale it is, lease, sale, exchange or otherwise. 15 small e. Now let senior advocate opinions for the IDCO submits that IDCO had only agreed to allot a plot to the petitioner. Why the which is that agreed to allot? Why the letter of allot is
letter dated 18/11/2010, Annexure 3.
18/11/2010. Why the Annexure 3?
Well, our only difficulty is that the earlier repetition, which was disposed of, the entire is annexed here with, and that document is being referred to.
Then we need not write as an example. All right. Let us read how it reads.
Page 32.
Let me offer for allotment or very
Lordship got it?
no.
That document. Annexure 3, your Lordship will find she has annexed the repetition, earlier repetition, page 18 it starts.
Malaj, it's part of Annexure 1, page 32.
Page 32.
Malaj.
Yes. Go to 32. Running page 30.
Yes, please. Running page 30.
Principle approval for allotment.
No, it's not running page. That running page of the repetition is
Old
different.
petition.
Different. Here different. There's some confusion in the repetition.
No, it is not this petition. Malaj, it is of this petition, Malaj. There is no confusion.
Anyway, no problem.
Previous
We
pages
cannot
have been
argue on
deleted.
page numbers. We can argue on the pages.
32.
Kindly read that.
In principle,
In principle.
approval for allotment of land at Chandaka Industrial Estate area
So,
on the basis of recommendation of the district single window clearance office, that is DSW.
yeah.
See, bonus.
So you had agreed to allot.
Yes.
But not allotted as such.
Not done. Then let's kindly
Counsel for
see.
the counsel for the learned senior advocate submits that the letter dated 8/11/2010, letter of allotment dated so and so, is a pure and simple approval for allotment, in principle approval for allotment, as distinguished from allotment itself, and therefore no concrete rights are accrued in terms of contract law.
But even no provisional allotment was given.
That you mean to say it has no value at all.
It was just communication that it has been approved, that it will be allotted to you. Then kindly see the second line. The 1 and 2 is there below that letter.
For establishment of
IDCO reserves the right
to change the size, alignment, location of the
proposed land at any time before issue of the provisional allotment land.
But where have you changed the size? You have to cancel the allotment itself. Where is the power?
Not cancel. That what we have said that, kindly see that page 40.
No, now you are, sir, you are reading this. Let us understand. It's important.
Yes.
All right. Second point you wanted to highlight. Let us understand what is that. Read that. What is that?
IDCO reserves the right to change the size.
Size you can change.
Yes.
Alignment you can change.
And alignment and or alignment and or location.
Location. But allotment as such is not alterable here.
It is a proposal to suggest to allot. But I understand to my perception. It is just an allotment to allot and allotment to allot, different thing.
No, there are two or different is all right. But Supreme Court considered this in they followed Justice Felix Frankfurter's judgment of US Supreme Court and repelled your contention. Take out that judgment. Raman Dyer, International Airport Authority was Raman Dyer.
79 Supreme Court.
79 Supreme Court. They have rejected your contention, banking upon the American Supreme Court decision of Justice Felix Frankfurter, where they said the same thing. Then Great Court said, Justice Bhagavati said, no, we cannot agree with that. Private men can say that, not a statutory body.
We are subject to control of the policy of the government.
Now that's another, we'll come to that one. On the first principle, I'm saying that.
To my perception,
Counsel draws attention of the court to condition number 2 in the letter of allotment. Person, when it is confronted to him that the said condition does not reserve right to disallow, comma, he says that the IDCO is bound by the policy of the state. It is no answer. In view of the decision of Justice Felix Frankfurter, which Apex Court has followed in R.D. Shetty and in B.S. Minas, 2 judgments at least. Okay. Next point.
Man. Then why he came before this Honorable Court? The cause of action is page 42.
Go to that. My officers have taken out that judgment. Go to that to Felix Frankfurter. Right down, Felix, F-E-L-I-X, Frankfurter. Huh? There. Yeah. Can you take out that judgment, Mr. Senior Advocate? Can you take out that judgment?
Yes.
We have read that judgment.
Yes.
Of Felix Frankfurter is quoted.
Yes. R.D. Shetty's.
In R.D. Shetty,
R.D. Shetty's.
B.S. Minas, it is
Yes,
there.
Madam.
B.S. Minas versus Statistical Institute. Now, B.S. Minas, they have said, they have omitted the word Felix. They have said only the word Frankfurter. What is B.S. Minas? Yes, it is there in page number.
Justice Frankfurter's observations.
There. Yes, very see this.
Yes.
An executive agency, to you, this is the answer. An executive agency must be rigorously held to the standards by which it professes its action to be judged. Accordingly, where I read in this further. If dismissal from employment is based on a definite procedure, even though generous beyond the requirement that binds such agency, that the procedure must be scrupulously observed. This judicially evolved rule of administrative law is now firmly established, and if I may add, rightly so. He that takes the procedural sword shall perish with the sword. The sword may fall on you.
My perception, my lord, I differ.
Of course, you are entitled to.
Because
every perception has to be adjudged in the light of the jurisprudence.
But your lordship has to judge it. I have to make my submission.
No, I gave you a hint, an opportunity.
Right.
Otherwise, suppose if I keep it in my mind and pass the judgment,
yes,
you will not be happy.
I should clarify.
You should thank me because I am giving an opportunity to you. Yes. You should not get offended. See, this is a marketplace.
Nothing to.
Court is a marketplace of ideas. I have my ideas for selling. You have your ideas for selling.
Right.
Whichever the consumers will decide, that will decide the things.
Right.
Yes, although I am not a consumer. Yes. The next point.
My lord, in this regard, what I beg to submit.
You need not beg. I am sorry against that word. It's your right to submit.
Yes, what I like to submit, that it did not create a right on the petition. It is only a promise. It is an intimation that this is, we are going to guarantee. That is my submission. So, Lordship, kindly see the impugned order.
It's that the allotment order as such would not create any justiciable right in favor of the petitioner in the absence of the same rectifying into a transaction, like contract.
In fact, we give the lease also. Lease agreement is signed after. So now, why he came before this earlier?
Yeah.
Because he was agreed by the letter dated 23/12/2013. That is page 42.
23.
Running page 42.
No. Yes. Annex 8.
Annex 8.
You are right. In principle approval for allotment
of land at Chanduka industrial area on the basis of recommendation.
The earlier one was Annexure 3 was dated.
Annexure 3.
18/11/2010.
10.
That is 2010.
Yes, ma'am.
This is 2013. This was your cause of action in the petition.
First,
Earlier petition.
Earlier it was. Then, so that is reference is with reference to subject cited above, it is to intimate that your proposal for allotment of so and so industrial area for setting up your proposed project was placed before the review committee constituted in the high level land allotment committee meeting held on 3/4/12 under the chairmanship of Chief Secretary Odisha. The review committee decided to reject the proposal and to withdraw in principle letter. Hence, the in principle letter number dated 18/11/10 is hereby withdrawn and the proposal is cancelled.
Correct.
Then let's kindly see, we had come up before this Hon'Ble Court.
The cause of action for the first petitioner was founded on the cancellation letter dated 23/12/2023 issued by the IDCO in the light of the review committee recommendation. First, there the judgment was entered, which learned senior advocate appearing for the petition high-level review heavily banks upon. But high-level committee is only English terminology. Where is the statutory sanction for that? Yes.
Then he had filed the writ petition, and in the writ petition, the order he has
that order has
he has read out.
Therefore, three things you have to now. One particular thing we have to. The orders of the court has to be construed in the light of the facts stated in the judgment. The facts stated are there was in principle approval that came to be withdrawn. That was challenged. You came up with a particular stand, and court structured a particular judgment in a way acceptable to both the parties because nobody challenged it thereafter.
Right.
Therefore, let us read the judgment. Now he has read that. Yes. There is one word which is highlighting, one sentence. There will be no problem for allotment, although one sentence cannot be taken away from the context. But still, you cannot completely rob off your stand taken before the Constitutional Court.
110. Page 15. Page 15. Page 15. 15. How to extra copy?
Petitioner wanted to open the hotel, whether hotel was closed.
No. We would have established the hotel.
Had even allotted the land.
You have said it 10 times now. Any other new point you want to say?
No. What I beg to say, I have not come to the impugnment order. Well, here, the contention was raised. Mr. Mukherjee, Lord Counsel for Info,
should not read name of the lawyers. Yes.
That is,
yeah, should not.
All right.
But you are not supposed to read.
And the Lord Counsel for IDCO, with his usual fairness, submit that the IDCO has no problem in allotting a plot to the petitioner for opening of a hotel if he agrees to pay present market rate. But it would not be done. Why? The high-level committee took a decision on 3/4/2012 in view of the principle decided by the government by the notification dated 12/4/10 in Annexure B/2 to the counter affidavit, wherein it has been decided that the government land in Bhubaneswar Municipal Corporation area will be not allotted to the industrial units at a concessional price. So, no final adjudication on this point. Regarding hard to the facts and submission, the writ petition is disposed of directing the petitioner to file a detailed representation before the CMD IDCO, making an offer to take a piece of land for opening up the hotel by paying the present market value for the same. If such an offer is made by the petitioner, the same shall be considered and disposed of with promptitude within a period of 2 months from the date of application, giving preference to the petition to allot a land and place where hotel business shall be conducive. If the particular plot by the Annex 3 is available, the allotment of the same in favor of the petitioner may also be considered. So it was relegated for consideration. So now that consideration order is challenged before your law. So let me just briefly let me state it.
Yes.
This is the order of the.
What is the ground on which you have rejected this offer? We will examine that ground, whether that ground is sustainable or not.
Yes. But here,
yes,
the high-level allotment committee for Bhubaneswar Master Plan region, in their meeting dated 3/4/12 under the chairmanship of
your friends can go for lunch so that they can return afterwards. This matter will take some time.
Others.
Yes.
Allotment proposal that are considered by the
otherwise I will ask them to stay back so that you will offer the lunch to all of them.
Allotment proposal that are considered by the subcommittee be reviewed category wise on case to case basis. In furtherance of this, a committee under the chairmanship of CMD IDCO, Vice Chairman PDA, Director of Industries and representative of Secretary to Government Revenue Department as members was constituted, and when the petitioner's proposal was placed before them, the committee decided to reject the proposal and withdraw the in principle allotment letter 18/11/10. Again, the proposal of the petitioner was placed before the review committee constituted as per decision taken on dated 3/4/12 by the high-level allotment committee. The meeting of the review committee was held on 25/9/13, and as per the decision taken in the said committee, in principle, approval of for allotment of land was rejected, and the same was communicated by letter dated 23/12/13 at Annexure 8 of the petition. Subsequently, the matter was again placed before the high-level land allotment committee for Bhubaneswar Master Plan region, which was held under the chairmanship of the Chief Secretary on 18/6/14. But again, the said committee approved the recommendation of the review committee. Further,
one second. What is the role under which section, under which rule this committee is constituted? Because power is given to you by the state legislature. Under section 15 clause A, it is for you to decide whether to allot or not. What is the role of the committee in the scheme of the act? Yes, sir. What do you say about that? What is that?
My lords, here the committee, my lords, whatever it has decided, they have to follow the government principles, my lords. There is a section, my lords. I've given the act to your lordships. There is a section. I think they have to follow the.
Which is that section?
I'll just, my lords, that because 2 copies I've given to your lordship.
Is it? Give them back. The act. What is the status under which section, under which rule the committee is formed? Give that back.
Act. Itco Act.
Which section? Please take them.
This is the
Take
rules.
These are the rules.
Another act was given.
Yes, here, wait, I'm sorry. I have written your Sir, you have to basically, you have to answer because you are representing the IDCO. Since you are representing that, you want to justify the action of IDCO, you have to tell, right, what is that committee? All high sounding, what high level committee? All right, it's an English term, that's all. Unless it is shown to be high in the eye of law, nothing is high.
Yes.
Under which, what is the status of this committee? How it is constituted? How it functions? What is the normative basis of functioning? This research has to be done.
But and this is chapter 6.
Chapter 6.
Well, it's 18, section 18.
18.
Yes. Directions by the state government. The state government may issue to the corporation such general or special directions as to policy as it may think necessary or expedient for carrying out the purposes of this act, and the corporation shall be bound to follow and act upon such direction.
Correct. But direction cannot be contrary to section 15A.
Yes,
15A gives power to the corporation.
Yes.
To allot or not to allot.
Yes.
What is that committee?
But my submission is that is subject to this.
You are submitting all that. But where is the role assigned to the committee in the statutory scheme? Direction by the state government is one thing. Decision by the committee. Who is that committee to reject that proposal?
That is only government.
But that will not help you. You have to say what is its structure, what is its legal status, why it has power to decide. These things have to be argued. Both are not arguing on that. And judgment also does not say anything about that.
Can it come to section 32?
32?
Yes.
Can we do one thing? Instead of turning the page after page, just both of you sit together.
Yes.
Work out a common on legal issues.
Yes, sir.
Factual, we can argue whatever. At least on law.
Yes.
Wherever you are agreeable, draw a common format of law. Wherever you disagree, you put your point, he will put his point. I will decide what is right, what is wrong. All right. When you will. With full preparation you have to come. This half-hearted preparation from both the sides will not satisfy me. And it will be wasting our time.
No. I understand.
People are waiting here.
Yes,
We both of us should discuss and
both of you should read.
Assist or not?
Both of you should read and come.
My lord, sir.
Whichever date you want, I will give you. These points.
What is the role of the committee?
We follow your lord.
That's all.
And the direction, what is the effect of? Because, my lord, I am relying on the state government's direction in 2010.
All that will not help you.
Yes.
Unless these basic questions are answered.
Yes.
What is that decision of the state government? The state government, it cannot, I am saying something in your favor.
Yes, sir.
Now, 15 clause A gives power of allotment by way of sale. Though section badly is drafted, it uses the word sell. Sale, exchange, gift, not gift, lease, or otherwise. Or otherwise is interpreted by the applicant at least in 3 judgments in the similar sections in various state legislations. I have seen them. Therefore, I am telling you, now you should say status of the committee, its a decision-making power, and normative basis for making such decision. It cannot say, you are tall and therefore I will give you. You are fair, therefore I will not give you. Such things will not run. The unfairness standards, which John Rawls wrote, justice as fairness.
Yes.
That standard, you should come out with research. Otherwise, your arguments are not impressive to me. Both the sides are not impressive to me. Anyway, I will not say more than this. Come next date. Yes. Whichever date you want to take it.
The 18th.
18? 18. Yeah. Call this matter on 8. The date is chosen by both the sides from the calendar full of dates. Obliged.
Item 46.
6 may I plead, madam. This matter will take some time.
We have time, 5 minutes. No problem. Start at least.
Some matter, my lord, where we have challenged the second order of litigation. The issue here is that, my lord, the issue here involved here is that
But the bank, who is the Central Cooperative Bank, and the petitioner as the employees of the Central Cooperative Bank, the bank has decided to extend the benefit of sixth pay commission to its employees, but the registrar has rejected the same on the ground that it will incur heavy financial loss on the bank. We have challenged that impugn order on the ground that the registrar has no authority over the said decision. The registrar has no authority to interfere with the management and the decision making of the bank, whether to give or not to give the.
No, bank, suppose if it's a bank, cooperative bank.
Yes, madam.
Is it not?
Yes, madam.
Bank is my money, your money, my brains. Bank is your money, my brains. So naturally, the state will have control over that.
State has
such a decision.
State has framed its rules.
Rules are framed.
Rules are framed, and in terms of the rules, the committee of the management of the bank
appears for the registrar. Where is that order? Registrar's order.
And the impugned order is at my lord page.
Can you take out that judgment?
16.
Bank is my brain and your money. Yes. I only have quoted it. Dixit also. I think it is Nigdesh Estate versus so and so. Take out that judgment. Yes.
Impugned order is at Annexure 16, page 40. 16.
This is made by the registrar.
By the registrar.
You say he has no power at all?
Yes, my lord.
Yes, sir. And what, Mr. Behra, where is the power?
My lords. And they have also not filed their counter.
Let them not pay. Let them show the source of power. Which section?
My lords,
if you know, argue. If you do not know, takes time. I will give
my lord's counter is not filed. That is the problem. I don't.
Problem. It is your problem, not citizens' problem.
My lord, this is a 2021 matter. Notice was issued in that year only.
That's the only point. Whether you have power, whether power is exercised in a normative way. These are the 2 points of administrative law. Nothing more. Whatever the thick the file may be, we can pin down to that principle.
My lords, the impugned order.
Yes.
Annexure 16, your lordship will find.
Yes. Which section?
The petitioners have approached the registers by because of the order of this honorable court. He is saying that it is a submission of the petition is that the register has no power. They have.
Suppose I and say, permit me to contract another marriage.
My lord.
Whether he will entertain my request?
No, my lord.
Because I have gone to him. He has to act under the statute.
My lord. And bank has taken a stand that they have no financial capacity.
How can the registrar poke his nose in the affairs of a private cooperative bank?
Because of the order of this honorable court.
But it said it gave power to you.
My lords, it was, my lord, the hearing of the case is taken up.
I'm asking you, which section gives power? Basic question of administrative law. Existence of power, exercise of power. Whole edifice of administrative law, which Wade and Forsyth will say, is founded on these two things. Existence of power, exercise of power. That's all. That is administrative law. Nothing beyond that. Whichever book, SP Sate, IP Massey, Wade administrative law, Basu's administrative law, all they are founded on this principle. The exercise of public power. Existence of public power, exercise is public power. The third adjunct is the existence of power per se is not a ground for its exercise. These are the three things. In the light of that, you have to say these things. He is saying he has no power. Let us see where is the power. You take time.
My lord.
Let him come in because he will have many cases. There are a lot of pressure on the
Only two documents. Only two documents I will place, my lord. Page 24 and page 27. Therein, the register itself has stated that the committee of the management of the bank is the sole authority to take a decision regarding the payment of revision.
No, that would be too extreme. Did you get that judgment? Yes, which is that judgment? Correct. In that apex court, my judgment. I followed 1932 Commission on Banking Reforms in England. I quoted it. Perhaps I quoted the Andharujina also. T.R. Andharujina? The great lawyer, Additional Solicitor General of India, he was Sirwai of Mr. Sirwai Jr. He was appointed as the chairman of Banking Reforms Committee, pursuant to whose recommendation our Surface Act has been enacted by the Parliament. The great scholar who assisted Sirwai in Keshwananda. That one? Take out that judgment. Just go through this judgment. It may give some link to both of you. All right? Ciao. Which date do we want? Yes. Mr. Behra, you needed time in that? The first week of December.
Can we pray for an early date if possible?
No, not possible. It requires a little consideration by him also. You have argued very well. I appreciate you.
The 2021
very articulately have argued. Wait. Now, as of now, I am convinced of your argument, subject to rebuttal by the other side. Wait.
Lordship, the management.
You have to answer those questions the next day. This is your argument.
Item 47.
May I please, Your Lordship?
Yes.
My Lord, this is relating to formation of alumni committee pursuant to the scheme of the state government.
What committee?
Alumni committee, alumni association. My Lord, Your Lordship may kindly see. No. Your Lordship may kindly see this resolution.
Alumni committee regulations are there?
No, that is a resolution of the state government relating to Mo School Abhijan, My School Abhijan.
Implementation of the
Mo School Abhijan in the state of Odisha for revamping school education by promoting volunteerism and collaboration through an innovative citizen government partnership. A robust and vibrant school education system holds the key to a brighter future for the state and its people.
What is the modalities?
My Lord, the modalities is, Your Lordship may kindly come to third paragraph. In order to fulfill above mentioned objectives, the state government has launched the Mo School Abhijan on the occasion of Children's Day, that is 14 November 2017, in order to encourage individual alumni associations, group of persons, institutions, social impact organizations, companies, foundations, philanthropists, and others to contribute to the enhancement of the school ecosystem. They will be provided with a platform to donate funds, materials, and services for overall development of the schools in the state of Odisha. The program will aim to prepare the future generation to evolve into dreamers, doers, makers, growers, explorers, experimenters, and entrepreneurs. Well, then Your Lordship may kindly skip over and Your Lordship may kindly come to clause 6 or para 6. Funds for the implementation of the Mo School program shall come primarily from two sources: contributions from donors, hereinafter donors, and twice the amount of each such contribution to be provided by the state government from a dedicated corpus fund. An initial contribution of rupees 100 crore has been made for the purpose by the government. Then other things are, then paragraph 8 deals with development of the school in a different aspect. My lord, thereafter, your lordship may kindly come to clause 17. The chairperson
or any other person
authorized by him, public her, the collector or any other person authorized by him, public her, the secretary, school and mass education department or any person authorized by him, public her, may inspect the educational institution where the project has been implemented to verify whether the work done meets the qualitative and quantitative outcomes envisaged for the project and is within the stipulated budget. Then other things are there. Well, pursuant to this resolution, an alumni association or committee that was formed consisting of 11 members, that was formed on 30/6/2018 under Annexure 1, that is in vernacular. My lord, since the president of the alumni committee, he misappropriated that amount because 7 lakhs and odd were donated by the donors and the state government provided 14 lakhs, twice of the amount. As per that scheme.
The whole money is misappropriated.
But he misappropriated part of, that is 3 lakhs and odd. So therefore, a committee, in the committee meeting, my lord, he was removed. And since 2 other members resigned from their membership, they were also removed, and in their place 2 new members were included. That was challenged by the president who was removed and other 2 members.
What happened to that?
Well, that writ petition is WPC number 21743 of 2022. And this Honorable Court, by order dated 30/8/2022, disposed of that writ petition with a direction to the district education officer to consider the grievances of the petitioners of that case by giving opportunity to all concerned. Your Lordship may kindly see that order. I have quoted that order.
By your version.
Yes, I have quoted that order. But, my lord,
whether that termination was set aside?
No, my lord, what has happened, my lord, without giving any notice to the alumni committee, which is functioning now, including the president, the district education officer held that the removal of the president is bad in law, and other 2 members, new members who have been included in the committee, their inclusion is also bad. Your Lordship may kindly see. And
that order WPC?
My lord, that WPC number 21743 of 2022. I have quoted that order at page 7. Page 7. My lord, your Lordship may kindly see paragraph 7. The paragraph 4 of that order at page 8. Dated is 38/2022.
You gentle lady, why are you disturbing that person? 21743.
So 21743 of 2022. That was disposed of on 38/2022. I have quoted that order at page 7 and 8.
Annexure?
No, annexure is not there. I have quoted. Your Lordship may.
No, what is your grievance?
Well, now the grievance is I am challenging the order of the district education officer on 2 grounds.
What he say?
Well, he says that removal of the ex-president, that is bad in law because there is no rules for removal, and therefore his removal per se is illegal. And
he cannot be removed at all in the absence of rule.
That is his findings. That is his findings. And number 2, he has said that 2 other members have been included, my lord, without the consent of the previous president. These are the 2 grounds on which their application has been allowed. My lord, my challenge to that order is, my lord, we are the president and members of the present alumni committee. we are also made parties in that case. But without hearing us, without giving any notice to us, the district education officer has passed the unilateral order. That is my first submission.
Two reasons are given.
Two reasons. These are the two reasons.
Number one is there is no provision for removal at all.
Removal at all.
Even if they commit mistake with the murder, they have to be continued.
Yes. In that way. Number two is two other members who have been newly included.
Inducted.
Yes, inducted. That is without the consent of the ex-president.
Whether it requires induction requires consent.
Because two members
who inducted.
Well, two members resigned from their post.
I understand.
Yes.
Vacancy. Well, the very same persons are inducted, or some other persons?
Some other persons.
Who has power to induct?
Well, committee. Alumni committee.
Where is that?
Well, power is not reflected in this resolution. So far as this resolution is concerned, power is not reflected. But since two members have resigned from their post or membership, therefore, by passing a resolution, alumni committee inducted two new members.
How many members were there in all?
11. And your lordship may kindly see the reasoning given by the district education officer. And my third ground is the district education officer is not the competent authority.
This is in the form of an association.
Alumni association.
Odisha Association Society Registration.
Yes. Society Registration Act we have.
Is it registered or not registered?
It is registered under the Society Registration Act 1860.
As a society. Under the Society Registration Act 1860, Central Act.
Society
cannot be.
My lord.
Central Act.
Yes. Society Registration Act.
You don't have State Act here.
No. It's a Central Act.
Central Act. No, 1860 is the Central Act.
My three grounds, sir. My first ground.
Reflecting on everything you have said. Your first contention is?
Well, the district education officer has no jurisdiction. No jurisdiction. Even if this honorable court conferred jurisdiction in view of the apex court judgment, and your lordship knows the position of law, the court cannot confer jurisdiction.
No, that's right.
Yes.
As long as the order conferring jurisdiction is kept intact, he has jurisdiction. It can be a ground for setting aside that order, as you said.
Yes.
But unless it is set aside, that order remains.
Yes.
And that order confers the jurisdiction. Nowhere in that judgment which you are referring to,
yes,
the court has said where the court has conferred jurisdiction, such a judgment should be ignored.
Yes.
It can be a ground for invalidation.
Well, your lordship may
review it. That well settled judgment.
Yes, your lordship may kindly see 2023 judgment.
No, that is well known to everyone.
Yes, well known.
In your state, I don't know whether your law students know.
Yes.
Because I'm not seeing even advocates not knowing. That is not necessary.
Yes, that is not necessary.
At all. Because
well, either the state government, my humble submission before your lordship is, either the state government or the collector, not the district education officer, because that is the scheme. Your lordship may kindly see
that which you read.
Para 17.
That is for the purpose of inspect the educational.
If any irregularity is done, the chairperson or any other person authorized by him, public her, the collector or any person authorized.
Done meets qualitative and quantitative.
Yes. Chairman, the allegation of misappropriation is there. Because from out of that funds, my lord,
it's a state fund.
State funds.
2/3, 1:2.
1:2.
2 is state fund.
2 is state fund. One is by donation.
Public donation.
Public donation.
So he could not have done that.
Yes.
Now, at the most, we can remit the matter to the deputy commissioner.
Yes.
The district
Yes.
What do you say, Mr. Ben?
It is a private dispute between the parties.
Private dispute.
Who will be the president of the alumni association? And the order.
District education officer.
My lord, what I humbly submit There was an order by this Honorable Court directing DEO to take a decision. It was open for them to seek review of that order or modification of that order.
That is an innocuous order.
No, but that granted the power to the district
education officer.
You did not challenge it. You were a party to that.
Yes, yes.
Therefore, you are bound by, you are adjudicated now.
Yes,
you cannot.
But there is no estoppel against law.
No, not law.
Res judicata.
You are adjudicated because of section 11 of CPC.
11 of CPC.
The second contention is
no notice, no opportunity was given to the alumni committee, including the present president.
Let him hear and decide it. But he only has to decide because it binds me also.
Yes.
Our own court judgment it is. It will be wrong judgment.
My lords, they were given opportunity of hearing it.
It should be given to the other members of the committee.
And the inclusion and exclusion, that is the reason given by the DU, that was done behind back.
But I have categorically stated, you will also see.
Behind back of whom?
My lords, the person who was removed was a member of the committee. He was not called to attend the meeting, my lord. That is why the order of removal was recalled by the...
No, how even that judgment is a wrong judgment.
And I have categorically stated in paragraph that has not been
7 of the counter, your lordship may see. And impugned order also, there is reference to hearing of the parties.
Which parties?
Petitioners.
No.
Petitioners are heard in the matter.
No.
You have not refuted that contention. You have not filed any counter at all. Where have you taken up that?
Para 7.
That petitioners were heard. And where is the evidentiary material? What notice you had sent with which postman went there?
That omnibus statement has been made that after hearing all the parties concerned.
That even computer will give that duplication. But question is, which postman went there? Who dropped the mail?
My lords, may I place the para 7?
Yeah.
That after hearing to all parties mentioned at length and on perusal of resolutions passed by the committee, it is revealed that Neha Ranjan Sahu and Kamalakant Parida are included in the committee as new members in a resolution dated 22/6/2022 without disclosing the facts of exclusion of 2 members on the said resolutions. It is
those 2 members were also heard.
No. It is
they have resigned and they are not before you.
The exclusion is not there, my lords. The 2 persons against whom
they are heard in the matter. They are the stakeholders.
They are the stakeholders.
But they are not before the court. They are happy with the exclusion.
My lords, since the earlier president, Sri Bhagavan Swami, was removed from president during his absence, the same was considered as illegal and void ab initio. And it is worthwhile to mention here that as per Annexure 4 series, the present petition, exclusion of so and so is not at all incorporated in any resolution.
No, that is wrong. Because in
what I propose, my lords, your lordship may remit
the judgment, which is that Justice Justice Sham Sundar of Karnataka High Court. He held, even when memorandum of association of a society does not give power to remove, that power is inherent in the committee. Otherwise, suppose he commits an offense, some very heinous offense like murder, rape,
like the general clauses said.
So far what I humbly submit, there is power to remove. Otherwise, somebody will commit some irregularity.
You have to retain him on the ground that there is no power at all. Cricket.
No, there is no procedure provided. That is what.
No, there is a judgment, a very rare judgment, one of the beautiful judgments. Matter was referred to Karnataka High Court by the Supreme Court, Honorable Supreme Court. Justice Shyam Sundar decided that matter. BCCI versus so and so. Take out that judgment, very old judgment which Kapil Sibal had argued. Very old judgment. Where it said, even when society did not provide for removal, still the guilty member can be removed from membership, as you rightly said. What is supposing? There are two things with which I am. Number one, there is rightly or wrongly, there is a judgment. The judgment had given power to district education officer. Therefore, first contention is not available to you. Number one. Number two, the second contention a bit difficult to countenance because they have not produced any material to show how notice was sent to them. They appear.
Fresh opportunity of hearing will be given to all the parties. After hearing them, fresh order may be passed.
That way. Kindly be seated.
And till then, that order may not be given effect.
My lord,
they said that order.
Yes.
Where is the question of giving? Yes. But till matter is decided, you shall not take any
financial
decision.
Financial and policy decision.
Financial decision.
Financial and policy decision.
Yes, yes.
Both.
And within a period of 2 years.
That 4 weeks, to 6 weeks.
My senior Mr. A.K. Pandey appearing on behalf of the opposite party number 8 man. And we have no instruction to proceed with the case. That's my humble submission.
That means you have no instruction to proceed with the case does not mean case cannot proceed at all. Suppose if I and you do not go to draw the Jagannath Rath, Rath will not stop. Same. Those who come, well and good. Petitioners are complaining before the writ court against the district education officer's order dated. Date of the order.
Date of the order 5/12/2022, Annexure 3.
5/12/2022 at Annexure 3, whereby he has annulled the removal of one of the members of the alumni association in question and found for the induction of 2 CWO. By the committee which comprised of petitioners as well. First. Next part. Learned counsel appealing for the petitioners seeks invalidation of the impugned order on the following 3 grounds, A, B, C. A. The district education officer has nothing to do with the affairs of the alumni association, which is a society registered under the provisions of Society Registration Act 1860. B. In front of that. The petitioners were not given an opportunity of hearing to the petitioners given, nor the stakeholders were notified. ABC. The due procedure has not been followed and therefore petitioners are prejudiced. Learned AGA, Mr. Behera, appearing for the official office, opposes the petition, refuting the submissions made on behalf of the petitioner. Firstly, he submits that the issue of jurisdiction is hit by res judicata in view of a coordinate bench decision in WPC 21743 of 2022, disposed of on 30 August 2022. Opportunity of hearing having been given, is mentioned in the impugned order itself, and therefore contention to the contrary is wrong. The impugned order has been made by the DEO after following the due procedure. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter as under and for the following reasons. Next point. Number 1. The first contention of the petitioners that the DEO lacked jurisdiction to intervene in the affairs of the association in question is liable to be rejected on the ground of res judicata in view of the coordinate bench decision to which they were also parties and which conferred jurisdiction on the DEO, rightly or wrongly, the same having not been put in challenge further. First of all, the apex court, the decision which you cited is of 2 judges.
This is
2 judges, I believe.
Yes, 2 judges.
2 judges. Give that.
The paragraph.
The
14, paragraph 14.
The reliance of Mr. Swain, learned counsel for the petitioners, on apex court decision in state of Meghalaya versus Union of India, 2023, SEC online, SC 613, to the effect that a court cannot grant jurisdiction on an authority or confer jurisdiction on an authority which otherwise lacks it, would not come to the aid of petitioners. First, as a broad proposition, its authenticity cannot be disputed. Is due, of course, subject to all just exceptions. First, in 1992 SC 111, paragraphs 5 and 6, a 3-judge bench of the apex court has held that an order or a judgment may be found. First one. However, it does not bear the brand of invalidity on its forehead unless the said order is set aside by a higher authority or court, even a void order would remain effective for all ostensible purposes. First of all, that is the view of Professor Wade in his magnum opus administrative law. Put that page. Just put that page. First of all, a judgment is wrong because it contravenes the established norm of law is one thing. The efficacy of a wrong judgment is another. Another. First off, a wrong judgment or a decree also attracts the doctrine of res judicata, as said by the sages of law, and decision to that effect alone in the law libraries. First off, admittedly, the coordinate bench decision dated 30/8/2022, having attained finality, there being no further challenge, its authenticity cannot be re-adjudicated by this court in equilateral proceeding like this, as rightly contended by Mr. Behra, learned AGA. First, next paragraph. The second contention of the petitioner that they were not given an opportunity of hearing appears to be true. First off, removal of a member or induction of members, you can say removal or induction of members to the society or association is a serious thing. First off, it may balance or imbalance the decision making, even in policy matters. Therefore, such a course cannot be undertaken while adjudging a decision of removal or induction, as the case may be, or bar end, both of them, case may be, as submitted by the counsel, Mr. Swain. First, the principles of natural justice are sacrosanct, at times being drawing sanctity from Article 14 jurisprudence. First one, I did. Even the God is said to have given an opportunity of hearing to Adam and Eve before punishing them for eating the proscribed apple in the Eden garden. Says the Bible. First one, that being the position, Mr. Swain is right in flying FLAWIG, the impugned order, and seeking remittance of the matter for consideration at the hands of the authority, whichever it be. First of all. Next paragraph. The vehement contention of Mr. Behera that the impugned order specifically mentions of the opportunity of hearing given to the stakeholders, would not come to rescue of the respondent. First one. Absolutely no evidentiary material vouching the contentions having been placed on record. First one. Which postman carried which mail to the petitioners is conspicuously left unpleaded in the counter. First off, when absence of notice is pleaded, service thereof has to be proved who contends to the contrary. First off, therefore, the said contention cannot be countenanced. Next paragraph. The last contention of Mr. Swain that the due procedure has not been followed need not be examined by this court in as much as matter is being remitted to the portals of District Education Officer,
OP number 6.
OP number 6, for consideration afresh after giving opportunity of hearing to all the stakeholders, including the petitioners, in a time-bound way. First, in the above circumstances, this writ petition succeeds in part. A writ of certiorari issues quashing the impugned order. Matter is remitted to OP number 6, the District Education Officer, for consideration, for a fresh consideration of giving opportunity of participation to all the stakeholders, including the petitioners hearing. All contentions of the parties are kept open, remain to be heard and decided within an outer limit of 3 months?
Yes.
3 months. Next, in the fitness of things, the petitioners or the alumni association shall not take any major policy decision nor any decision having financial implications till after and subject to decision on the remand. No pass.
Item 48. So in item 48, my lord, to kindly see the last order.
Yes, sir.
Order dated 18/9/2025.
Yes. Isn't it right? Heard at length on 2 occasions, though it appears to be very innocuous. There are several implications, consequences. The system of this order, the old strength of the conditions. However, what is that strength is not mentioned. Both the section upon the text of 11.3 that speaks of standard laws, and it has nothing to do with the language or subject, namely Urdu reading. In view of yes, as to what is the strength of Urdu students in all the schools in the state, wherein the Urdu teachers are appointed as rescue teachers, drawing rupees 7,400 resource teachers per month as their lump sum remuneration.
But so far as my client is concerned, he has obtained information he has sought for information under the RTA Act, but that information has not yet been supplied to him. So, whether the state has
applied. So far the present petitioner school is concerned, that information we have since 1980.
Not all over the state, it has to be.
All over some more time, because so far the list of Annexer 8 is concerned.
December, for complying with the order dated 18/9/2025. First, non-compliance may result into drawing adverse inference. No, that cannot be, because this is put on both the sides.
Yes.
Adverse inference against the
state.
OPs.
And so far the
petitioner's RTI application has been dated
24/9/2025.
24/9/2025 is said to have borne no fruit.
Yes.
Even when application is made, you don't do not supply the material. What the citizen should do, you should ask your officers to be little sensible.
Can this information be put in the record?
Yeah.
So far this information.
Last
already there with us now. Question is, I wanted to know all the financial repercussion of my judgment. That's one of the factors. Because 7,400 in all schools in the state, we do not know whether what implication it will have on the budgetary position of state. I do not know. Therefore, I wanted to give an opportunity to you. It is in your favor.
Yes.
All right.
And fixing it to
second week of December. Well, I do not understand that. As a party, he is entitled to all the information.
Obviously.
As a non-party, he is entitled to information under the RTI Act. That information is withheld. How he should litigate? It is tying the hands of soldier and asking him to fight with the enemy. You being the enemy, you means you are the Yes. Open 49.
May it please your lordship.
Yes.
My lord, this petitioner is raised about
PCI. Huh? No. Read it loudly. Yes. Aha. This was the doctrine 1885. It must be 1885. 1890. Yeah, it includes power to regulate laws. Yes.
May it please your lordship. And the petitioner is about 72 years for a period.
Therefore, no bride will agree to marry him now.
My lord, since 2010, over a period of 15 years, he has filed number of cases. The present proceeding would be a fifth round litigation.
Except for
Annex for that I am coming to you, lordship.
No, I will not adjourn the matter now. So that I can take up the matter and grant relief.
Yes, 23.
23.
Yes, my lord. That it is grievance is relating to promotion. Grievance is relating to promotion. When my next junior got the promotion, my lord, I have
retired.
My lord, I retired sometimes 2011. 11 years after.
28 February 2011.
And while in service,
he joined in 12/1/1972.
Yes. What happened?
Joined as?
assistant teacher in the primary school. And promotional post is promotional post is headmaster.
From assistant teacher to headmaster.
Well, what happened, my lord?
Just I want to the foundational things. First, the promotion was granted to whom?
My lord, one
What are the eligibility criteria for promotion?
My lord, he filed a writ application, one Surendra Nath Pal. In the writ application, it was directed for consideration. Bypassing DPC and everything, his case was considered, he was granted promotion. He is eligible. I am also eligible. Now, when he got, I filed a representation. In fact, I have clarified everywhere that I have no grievance against him. My lord, yes, I don't want to disturb him because posts are there, but I may be granted promotion from the date he has got. This is the only.
Whether he is junior or you are junior?
He is junior. Placement is 8. I am 3.
You are
in the gradation list.
Gradation list dated?
Gradation list. In this writ application, I have not annexed, but annexure 1 is the tribunal's order. I first approached the tribunal. Tribunal when he got the promotion, and I had filed the representation.
Tribunal say?
Yes, tribunal in the first occasion, first instance, said to consider my representation. So while considering my representation, my lord, they introduced a subterfuge to defeat my case. What is that subterfuge and searching ways and means? Your lordship may kindly see. They said that I faced a departmental proceeding.
What happened to that?
Yes, in departmental proceeding on the ground that I had joined the training course without taking permission. In fact, permission was taken and I have been exonerated. In that departmental proceeding, I was exonerated. Then they said,
tribunal say?
Yes.
Tribunal's order.
Yes, I am correct. Tribunal, the first instance said, consider.
That is the rule.
In the representation, yes, my lord.
War is happening. You will say consider the representation.
So what happened in the representation, it is reflected that even if you are exonerated, we are going to file the review. On that ground, they rejected my representation. I filed the second approach to the tribunal. That is annexure 1.
That is their OA number?
That is OA number 3459
of 2010, 24 to 2010.
Yes.
What's the order?
Yes. Your lordship may kindly see page 14.
14.
Relevant portion. Hard. Hard land and standing comes from.
Hard is not necessary. Go to the last portion, operative portion.
Operative portion. After hearing both parties, 16.
Page 16.
After hearing both parties, it is apparent that powers of review can be exercised by the authorities other than the government as Rule 32 of rules, where a limitation of 6 months from the date of issue of orders to be reviewed has been passed. In this case, it has been proposed to review the order issued on 22/10/2008. Hence, such review is unjustified as per Rule 32 of the so-and-so rules and has been rightly withdrawn as per letter number so-and-so. Thus, it is now apparent that there is no departmental inquiry pending against the applicant as indicated at Annexure C/4 and Annexure 5. Hence, there should be no bar for taking up the promotion of the applicant after observing necessary formality if the same is due before applicant retires. I was in service, the order was passed.
It said only no bar to consider you for promotion.
That finding is there. That bar they had pointed out to review, that is there. So then I filed a contempt application for 11 years. It was not considered by the department. 11 years. It is 2011 Annexure 1.
Contempt case number, contempt case number is
contempt C 130 of 2011. It is directed for implementation.
Page number?
Page 19.
Contact 130. They direct what it said?
For implementation of the order if it is not implemented. That was the order in contempt.
Please read that.
it appears that the order of the tribunal has not yet been complied with. Let the opposite party comply with the same. If not already complied with the meantime, within a period of 3 months from the date of communication, production of a copy this order. My lord, that is the order dated 26/11/21.
What kind of order?
Yes. Thereafter, my lord.
This is dated
26/11/2021.
2011. You wait another 25 years.
So, they under Annexure 3 said, my lord, the known principle, they, in the guise of delaying the matter, they said that page 22, further the petitioner has retired on 28/2/11. Now it is a question whether his promotion will be awarded with a retrospective effect on passing the tribunal order. My lord, I was in service. My lord, I was allowed to retire. My lord,
if you permit me, can I put questions now?
One point I just said. So, challenging.
Your case, I have what you say is, your junior was given, he was serial number 8. You are serial number 3. Your case for promotion was not considered, but he was granted promotion. Therefore, you will be retried now, saying, I should be given the promotion. And you had no issue with grant of promotion to him. You were happy with that. You had no grievance. Only thing is, you should be given the promotion. What they said is, no, he was facing disciplinary inquiry. Tribunal made it clear. There is no question of disciplinary inquiry at all. Therefore, there is no bar for consideration of his care for promotion.
Yes.
Then you filed contempt. First contempt. First contempt.
Only contempt, no further contempt.
Only contempt.
So,
now what is that order you have challenged?
No, Annexure 4, before going to Annexure 4, under Annexure 3, page 22, after the contempt, they wanted some clarification from the government in the guise of delaying the matter that a known principle that whether after retirement. I was in service, order was passed, time rolled on, I was retired. Then, my lord, I filed another writ application. This one said, take a decision on Annexure 3.
Which is that WP? WP number?
28384.
28384.
2022.
Yes.
Much of writ jurisdiction is developed by you members actually. No other state will compete with you people.
So, my lord,
decided on?
Decision
28384 of 2022. Decided on
31st October
22.
It is at Annexure 4, Miller.
No, Annexure 4 is the order which is outcome of the.
No, reference search. 31st 2022.
One thing, I want to levy a cost of rupees 1 lakh. Yes.
Malad, may I read the order itself?
Read everything you read, no problem.
But I am reading out that Annexure 4, which is the impugned order, Miller.
Yes.
Which is
I'm
that
only asking, on what ground the impugned order is structured? There is seniority list, gradation list. Admittedly, he is serial number 3. That person was serial number 8.
Yes.
You have given promotion to him, but you did not give it to him. The ground pleaded was he was disciplined in the inquiry. All the way he ran to the OAT. OAT said there is no disciplinary inquiry. And you should consider his case for promotion. Then you did not do it and you filed the contempt. In the first contempt, time was given to you. You did not do. He did not go for second contempt. Then no decision was taken, then he filed another writ petition. Court again said you take a decision. And you took a wrong decision. He is in the evening of life. Having served from
1972 to 2011.
Were you born in the year 1972?
Yes, ma'am.
You were born?
Yes.
What, which 1 year or 2 years old?
2 years.
2 years old. Even then he has been fighting the legal battle. What he will do with the money, I do not know. Anyway, it is his right. It is his right.
I'm conscious, ma'am. Going by the records, may I place that last part, ma'am. so far this order is concerned, it has been passed in pursuance to the read which my lords has referred, 28384 of 2022, which was disposed of first 10/2022, my lord. I'm reading the relevant para with the cost of repetition, my lord. As reported by the Block Education Officer Baleshwar, OP number 4, gradation list of the teachers under such category school having trained graduates qualification was prepared by the Circle Inspector of Schools, Baleshwar District, such and such. In the gradation list so prepared, the name of the petitioner was placed in serial number 3 and Sri S.N. Pal, cited teacher, at serial number 8. When Sri Pal was promoted to the post of headmaster in the government ME school, in the office of order number 176 dated 16/1/2010 of the erstwhile DI schools of Baleshwar, the petitioner Sri Behera being agreed by a representation from his promotion, the post of headmaster, since his junior in the gradation list have been promoted. On to the next, from the report of the OP number 4, that is the BO Baleshwar, it is apparently clear that the petitioner Sri Behera has completed BD training course at Balyapada Training College as regular candidate during the day shift from 10 a.m. to 4 p.m. in the year 1985 to 86. May I say, at the year 1972, when the petitioner joined in service, untrained, it is not disputed, my lord. For the training course, he has done BD in the year 85-86, my lord, as a regular student from the shift 10 a.m. to 4 p.m. And without prior intimation, my lord. Then I am skipping the last part, my lord.
Which rule requires for doing course of the kind? The permission is necessary.
When, my lord, the in service, there are two categories, my lord. The persons, those who have been entered into service, having BD, OTT, CT qualification, they have completed, then joined, my lord. Some of the candidates, those who have joined, given the in-service training, they are known as in-service candidate, my lord. So, with permission, due permission of the authority, they can go for the training courses and completion of the
that contention. Did you take up that contention before the tribunal?
Before the tribunal?
Yes. When tribunal say he is entitled to promotion, how can you go behind the order of the tribunal? You are a party to the tribunal's proceeding. Res judicata applies to the king also.
Yes. That is the law of the land.
Law of the land.
That we cannot dispute. May I take a short time? 2 days. I'm conscious that it is a year-old case.
So how much time we have spent now? Now, my only question is, what I suggest is, on the next date of hearing, if you bring the promotion order with all benefits, I may consider your request for waiving part of the cost. Otherwise, it's a case for 1 lakh. It's a 1 lakh case. How many years have been lost? What he should do at the age of 72? In the evening of life, people will have many problems. The other problem is the one which the government has created to him. In court also. We also create lot many problems by our loose writing, considering cause of the people very casually, as if nothing has happened. I will give you time. But on that day, if you do not come with the order, then and that amount will be recovered from all the hearing officials. Because why state people should pay for your fault? Matter is extensively heard. First of all, very reluctantly adjourned to first week of adjourned to 19th of November, at the request of learned AGA. Yes. Item 50.
This case.
Only one point. When was promotion granted to serial number 8?
That was in the year 2009. So I came 10.
2010.
Yes. And it is exonerated the fact that I have been granted permission to join the co. That is their submission.
90.
Nine, no worry. Tribunal is the 9.
You were given permission to join the course also?
Yes, that is the finding in
the tribunal.
While exonerating.
No, I'm asking. That was a tribunal's finding.
No, my lord.
The inquiry was in relation to that one only.
Yes, yes.
That inquiry.
Yes, that is the
in
finding.
relation to that you studied without
permission.
Yes, but that was a finding in that with permission.
No, I want to know.
Yes. Minor lapses that I joined the without taking cost.
The tribunal has recorded a finding as to the non-pendency of the criminal, the disciplinary proceedings relating to petitioner making value addition in 1985-86. Sans permission. Okay. Just put that. Item 50?
Yes, may I please?
Yeah.
But this case has got a checkered history. So many litigations were filed. The petitioner retired from service on 28/2/2023 from the post of
grievance.
Well, the grievance is after 30 years, they are saying that I have produced fake certificates starting from HSC to MSc Zoology. That is their contention. And the contention was raised because of personal rivalry after 30 years. My cousin brother, in 2019, he approached this honorable court by filing a writ petition that I have got employment as a lecturer initially. Subsequently, I was promoted to the post of reader by producing fake certificate. This honorable court directed for first and innocuous order directing for disposal of his representation by the UP number 1, that is by the state government. Immediately thereafter, I filed a writ appeal. In the writ appeal, this honorable court abrogated the action of that person and set aside the order of the honorable single judge.
Petition also.
Yes. Thereafter, he set up another person and he filed FIR against me in the local police station. When the FIR was not registered, he approached this honorable court by filing CRLMP, and that CRLMP also dismissed with 50,000 cost. He went to the honorable apex court. He also lost in apex court. Thereafter, notice was issued to me that you appear and produce the certificate. Then I took a stand that my original certificates were lost way back in the year 2011. I have lodged an FIR in the local police station and it has been diagnosed. And he also obtained the Xerox copies of the certificates starting from HSC till MSc from the college, because that is available in the college file. My lord, thereafter, the state government directed for a crime branch inquiry. Crime branch inquiry has also given a clean sheet to me. That inquiry report is also available in this file. Now, thereafter, again I approached. When my pension was not paid, then direction was by this honorable court that let the state government take a decision. Now the state government has taken a decision that inquiry is going on, and unless and until inquiry is completed, you will not be favored with pension or retirement benefits. That is impugned order.
You were appointed to which state?
Well, I was appointed as a lecturer in zoology on 12/1/1989. And I joined on 16/1/89.
As a lecturer?
Lecturer in zoology. My appointment was validated and approved and I got salary from the state government.
Zoology.
Yes, lecturer in zoology.
Retired on?
My lord, I retired.
Promotion as reader?
Reader, my lord, I got lecturer group A scale with effect from 2010 to 2017 and reader state scale with effect from 10 to 2021. Annex 6.
And retired on?
I retired on 28 to 2023. Annex 9 at page 42. And I have, my lord, thereafter, I applied for all the certificates under the RTA Act. Since
certificates by the university.
University.
University will have records.
My lord, university is not supplying. My lord, I have annexed that additional affidavit. Only the Ravensa University has given me the tabulation register of my MSc certificate, MSc course. That is there. Your Lordship may kindly see my additional affidavit. My lord.
Ravensa University does not dispute that you studied there.
Yes. Ravensa University says that my name is not visible, but my name is visible, and that document is there. Your Lordship may kindly see that.
Your surname is there?
Yes, yes. My lord,
father's name is not mentioned?
My lord, that is not visible according to them.
Father's name is also not visible?
No. Here, Your Lordship may kindly see, that is at page 93.
Father is not visible, I can understand.
No. My lord, may kindly see 93, page 93. And so far as other certificates are concerned,
they are there.
No. They are saying that it is 40 years old, that is not available. That is 50 years old, that is not available. Like this. All the informations I have obtained.
When you passed out?
My lord, Your Lordship may kindly come to my additional.
I'm only asking.
Yes.
89 joined.
No.
Prior to 89, I have.
It must be prior to.
My lord, that is BSc 82.
BSc in 82.
BSc. That was 72. BSc 82, ISc 80, MSc 1985.
What is that ISc?
Intermediate science.
Intermediate
science and arts and commerce, three streams.
By then, +2 was not there.
Okay, equivalent to +2.
+2.
ISc. Intermediate in science.
Which year?
In 90. I appeared in the examination in the year 1980.
No, BSc in 1982.
BSc, thereafter BSc.
It is, how can that be 82?
Well, 2 years course. After I passed the ISc examination in
1980.
80. I am saying 80. 82 BSc and MSc in 1985.
Any complaint about your performance as a lecturer?
No.
You were given promotion also.
I was given promotion. I was given my pay. Only last month's pay was not given. And no proceeding was initiated against me. No criminal case. And only crime branch inquiry was directed. And you will kindly see the report of the crime branch.
They said there is no case against you.
Yes. Your Lordship may kindly see that.
Why, brother, you have to know that question may not arise at all.
My lord, after this allegation of this fake certificate at the time of initial joining in the year 1989,
yes.
Subsequently when the allegation was made, then definitely they have been given an ample opportunity to produce the same.
What produce? No. Question is, he was appointed in the year 89.
Validated in 92.
Promotion in February 2021.
Yes.
He retired on 28 to 2023. And now after retirement, if you seek, you are...
before retirement.
That is in 19 by a private person.
In 19.
You did not do that.
Yes.
No.
Some other person filed the case. Court said consider the person. He filed writ appeal. And writ appeal, he succeeded with a cost of rupees 50,000 on him. He went to Supreme Court. He lost it. His brother-in-law.
Yes.
But despite of that, with all fairness, when you instructed the petitioner to submit the relevant document in respect of his qualification,
Lost the documents?
No, that is the crux of
That is also reflected in the crime branch report.
No, he did not come up. Did you hold inquiry? He does not come. You could have held the inquiry and decided the matter ex parte. You have not produced any material. Therefore, they hold you guilty.
we have given all opportunity to the person concerned.
Correct.
No, my lord, did not produce, but at the same time, they have taken a stand, it has been lost. Damage in the cyclone. But later on it is ascertained.
You have given a good idea to me that we can make use of this cyclone also.
No, this has been fused.
Read a definition of pension in Constitution.
That is a property.
There is some article there.
That is not a bounty.
No, not that. Definition of pension. Pension is the remuneration for the past service. I think there is the definition given in the Constitution itself, or article. Not that. You will give all 100 books now. See that. Therefore, go to that. 370, something like. Can anybody help us? Which is that article which defines pension?
Yes.
There is a definition clause in the Constitution. Article 317. I don't remember.
In the judgment, constitutional judgment, DS Nakar ID is also reflected.
That's the reflected. D.A. Desai's judgment.
DS Nakara Devaki Nandan.
Pension is not a bounty.
No, that's not it. Devaki Nandan Mishra versus
Devaki Nandan. Yes. It's a property.
300 was
300 capital laid by destiny.
No, not that. Definition of pension.
Pension.
Is given in the Constitution. Article 317. Not 317. Where is that? Which is that pension? Go to definition clause of the Constitution. So many youngsters in the court hall, nobody assisting, nobody being fast also. It's very, very slow, sleepy. Yes. And you are also like that. Well, 10 second.
Article 366-17. Article 366-17.
Correct. Article 366 sub Article 17. Read. Pension means a pension, whether contributory or not, of any kind whatsoever, payable to or in respect of any person, and includes retired pay to payable, retired pay so payable, directly so payable, and any sum or sums so payable by way of return, with or without interest thereon, or any other addition thereto, of subscriptions to a provident fund. This is how expensive pension has been defined. There are judgments which say pension is consideration for the past service. In the Devaki Nandan Mishra versus State of Bihar, which truly referred to. That is referred in DS Nakara versus Union of India. My question is, on the ground that he gained employment by the fake document, you could have terminated him. That came to your knowledge when you were still in service.
Still in service.
When it came to your knowledge?
This is in 2019.
When? Then your case is worse because in 2021 you have given him promotion. Why did you give the promotion? You could have sent him back, or you should have hanged it to the nearest tree in your compound. Having taken service from January 1989 to February 2023, and having given promotion, after coming to know that he has procured employment by producing fake certificates. Can you now be permitted to contend? No, your appointment is bad. You have given promotion. In 2021 February, after the allegation of production of the fake certificates, why did you give promotion? This appears to be case another one lakh.
Manoj, because we have given all opportunity.
He did not.
He did not. He not cooperated. Manoj, kind of.
No, I will say he has been a BTS, but which prevented you from holding the inquiry?
In 2022. Still then didn't cooperate.
Can you not hold the inquiry expert? Expert inquiry can.
Thereafter, 23 order has been passed.
Saying that your appointment is itself bad. You want to recover that money also. Not permissible. At this length of time, whether when Babur came to India in 1526, he came with 5 people or 7 people, can it be gone into? There are certain shits where you have to try a curtain, life being short.
But at the same,
dig the graves like that way. Digging grave is not a wise thing. Why did you promote him? There are at least 2 judgments of Nagpur High Court. Once promotion is granted, presumption is all minus points of the employee are condoned. There are such judgments. Take. Can you see? Petitioner gained employment as a lecturer in zoology. Wide appointment order dated 12/1989.
I have also prepared it.
This will help.
I have given a date chart. I have given. Achha.
This was after selection. Conducted by the governing body. Then, first. Petitioner reported for duty. He reported for duty with effect from 16/1/1989. First, petitioner's appointment to be validated in terms of the Validation Act 1998 with effect from 1/4/1992, presumably issue as to the validity of class of such employees having cropped up in the state. First, he gained the promotion to the post of leader, as it then was, with effect from 10 to 2021.
With effect from 1/4/2019.
1/4/19?
Yes. Order was passed on 10 to 2000.
It was the effect from 1/4/2019 pursuant to order dated 10 of February 2021. First, he demitted office on attaining the age of superannuation on 28 February 2023. First time. He is knocking at the door of written word for assailing the order dated 2/12/2023, whereby the Commissioner cum Secretary, stroke Special Secretary to Government, has in a way indefinitely held the terminal benefits of the petitioner on the ground that petitioner is not coming forward despite granting abundant opportunity to produce the educational certificates, and therefore the inquiry be kept open against him in eternity. First. Next paragraph. One sentence. With that ground, the impugned order rejects petitioner's representation dated 23/4/2022 for grant of terminal benefits.
Yes.
For grant of terminal benefits, including pension, etc. First, next. Learned counsel for the petitioner pressing into service, PK DS Nakara versus Union of India, submits that pension being the consideration for the past service rendered by an employee, has to be sanctioned and released to the petitioner, especially when there is no fault on the part. Person. He also narrates certain cases.
Devkinandan Prasad versus State of Bihar.
No, that is considered DS Nakara considers that judgment.
State of Jharkhand and others versus Jitendra Kumar Srivastava and another.
Yeah. You give that citation also.
Yes, yes.
May not be. They only reiterate what is Nakara and
2013
Mishra.
Yes. 2013 12 SCC page 210.
He also draws attention of the court to the checkered history of the case, which involved certain allegations against him as to procurement of the public employment by production of fake certificates. First, his brother-in-law himself being the complainant in that regard, the proceedings were drawn before this court and they went before the division bench, which eventually handed a judgment in his favor, levying a cost of ₹50,000 on the complainant.
The cost was levied in CRLMP number 791 of 2022, filed by another person, Biswajit Patnaik, who was held by that.
The efforts of complainant having failed, some other person launched a criminal police case against the petitioner, which came to be quashed in by a court in criminal
CRLMP number 792 Yes.
Miscellaneous petition number
791 of 2022.
791 of 2020.
Decided on 25/1/2023.
Disposed of on 25/1/20.
Where 50,000 was
levying a cost of 50,000 on the complainant. And the second complainant. He took the matter to Supreme Court.
Yes.
Matter carried forward to the apex court of the country in SLP number.
That number is not to
country, and there also with no avail. First. Therefore, he submits that the OPs are liable to sanction and release all terminal benefits with interest.
And crime branch inquiry was also there. That is, report is there.
He also adds that the investigation was conducted by the crime branch of the state. What is that number?
That is,
and the report exonerating the petitioner from all charges.
That is under Annexure 12.
Was prepared
9/1/2024.
9/1/2024.
Report dated is 30/12/2023, and it was
23
supplied to the petitioner under the RTI Act on 9/1/2024.
Next, have you filed the counter?
Yes, ma'am.
Yes.
I have filed the counter and taken the stand.
After service of notice, the OPs having entered appearance through the learned AGA have filed a counter resisting the petition. First of all, Mr. Mohanty, learned AGA, vehemently contends that once the public employment is procured by producing fake certificates, no benefit can be derived by the fraudster, fraud vitiates everything, and therefore, person who produces fabricated document is no less than the fraudster, and therefore, no relief can be granted to the petitioner, whether it was, which is meant for scrupulous litigants. First, he also tells that despite granting abundant opportunity, petitioner failed to produce the genuine certificates or document to vouch his claim that he had studied ISc in 1980, semicolon, BSc in 1982, and MSc in 1985, and thereafter, in a scrupulous way, he got into public employment. First, he also submits that fraud vitiates everything. Why the P. Changalavarai and Idu versus Janardhana, and therefore, take out that judgment. Petition is liable to be rejected. First, having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under the following reasons. Number one, there was a selection process which eventually resulted into issuance of appointment order to the petitioner on 12/1/1989 as a lecturer in zoology. Petitioner reported for duty on you said some other date, 16/1/1989, having the appointment order at hand. 7. He earned promotion to the post of reader with effect from 10/2/2021, and he retired on 28/2/2023, are not at all in dispute. First time. Petitioner has been paid salary attached to the post in question in which he worked. He is also not in dispute. First, however, for the petitioner makes it clear that his salary for the last month preceding the retirement has not been paid. First, be that as it may. The allegation as to petitioner having produced fabricated documents, secured public employment was made way back in the year 2019.
1989.
That allegation itself was made in 1989.
No, allegation was made in 2019.
2019. And it was by none other than by his brother-in-law. Namely,
My lord, by filing a writ petition.
No, his name.
His name is Gajendra Pradhan.
Shri. Mr. Gajendra. Shri. Don't put Shri or Gajendra. Just Gajendra Pradhan. WP number. What is that WP number? He had to file
4468 of 2019.
You had to file that person has filed WP number 4468 of 2019.
That order I have quoted at page 7.
By making the said allegation, wherein petitioner happened to be OP number 8.
Yes.
First, a coordinate bench of this court by order dated 15/3/2019, ex parte directed the authorities to take a decision on the representation filed by the petitioner, filed by said Gajendra Pradhan. You were not served with the notice.
No, I was not served.
Petitioner filed
WA number
writ appeal number 283 of 2019. And
page 8.
The division bench of this court by order dated 15/7/2019 set aside the order of the learned single judge. First. Yes. The allegations made against the petitioner where the complainant came to an end. Next paragraph. Some other person, who is that person?
Biswajit Patnaik.
Another person.
That SLP number is also there. That is
person, Vishwajit Patnaik. Vishwajit Patnaik had lodged a police complaint against the petitioner in the Brahmagiri police station. You had challenged it.
No, he had challenged. When his FIR was not registered and the investigation was not made, he approached this honorable.
Since the complaint was not registered, the FIR was not registered by the police, he had filed CRLMP number 71 of 2022.
Page 14. I have quoted that order.
Which came to be dismissed. While order dated 25/1/2023.
Yes.
With a cost of rupees 50,000.
Thereafter, Supreme Court order.
Aggrieved thereby, Mr. Patnaik carried the matter to the apex court in SLP.
Special leave to appeal.
SLP number?
SLP number. Special leave to appeal, criminal number 2257 of 2023.
2257 of 2023.
Special leave.
SLP criminal it is.
Criminal.
Yes. SLP.
Order dated 2/2/2024.
That came to negative. Subject to by the apex court on
2/2/2024.
2/2/24. First. Thus, the allegation against the petitioner met a decent burial once for all. Next paragraph. Admittedly, the allegations as to procurement of employment by releasing false documents was known to the OPs long before. And more precisely on
2019 when complaint was made.
No, more precisely when the complaint was made by his brother-in-law.
Yes.
Way back in the year 2019. Any date is there on complaint?
Date is not there.
First off, had he given any representation to you?
Subsequently, they have given.
They have given subsequently. But in criminal,
he also
in criminal petition, criminal mistake petition, state is a party.
State
is a party.
But it is a dispute between their relations and them.
State is not a party.
Well, the crime branch
It must be a party because
state is a party.
State the complaint. FIR.
It is a party.
This is a non-registration of the FIR.
And in the crime branch, he made a representation, and at his behest, crime branch conducted the inquiry.
This is subsequently or before?
Subsequently.
This is subsequent.
Subsequent to levy of 50,000. No, that was another person.
That was another
person. Here, Pradeep, here the complainant was.
And the inquiry was completed in the month of December 2023.
By the police?
By the police, crime branch.
Fortnight was the complaint before the crime branch.
Second person.
A second person. You also may kindly see that report. It starts from page 52. The last page is 54.
There, the records reveal that the crime branch of the police, having investigated in matter, gave a clean chit to the petitioner. Why the report dated?
30/12/2023.
30/12/2023.
Annexure 10 page.
This would weigh heavily in favor of the petitioner. Next paragraph. The stand of the OPs that the petitioner did not come forward despite issuing of notices several times with the evidentiary material to vouch his stand that the documents are not spurious and therefore the eternal benefits have not been paid to him is very difficult to countenance. As already mentioned above, in January 1989, he was given the appointment. Please be seated. Yes. Both of you was given appointment in 2021. He was given the order of promotion with retrospective effect from 2019 as the leader. Promotion as leader. Even he retired in February 2023. First, the contention that petitioner did not come forward with the required document would not come to the rescue of the OPs, who could have held ex parte inquiry if they wanted. What? First, there is no justification for holding any inquiry of the kind, especially on the side and on the criminal side, matter having been looked into, the allegations were wiped out, giving a clean chit to the petitioner. First, even the police did it. First, at this stage, and in that fact matrix, no purpose would be served by keeping the contemplated inquiry against the petitioner in eternity. First, counsel for the petitioner is more than justified in submitting that pension is no longer a bounty, after the diction of the apex court in the Devaki Nandana Mishra versus in state of Bihar. followed by D.S. Nakara, etc. Withholding pension is also in a way offensive to the 300 capital A jurisprudence, Article 300 capital A jurisprudence in the right of apex coordination in KT plantations versus state of Karnataka. First, the money payable to the retired employee is his property, and therefore withholding it indefinitely amounts to its acquisition, at least temporarily. First, in the above circumstances, this petition is allowed. The writ of certiorari issues quashing the impugned order, coupled with the writ of mandamus to OP numbers.
OP number 2. 1 and
number 2.
1 and 2.
1 and OPs, you say OPs. To sanction and release all terminal benefits in favor of the petitioner within an outer limit of 8 weeks, with the interest at the rate of 12% per annum, reckoned from the date, to be reckoned from the date on which they ought to have been paid. With one more paragraph, above grounds. Withholding of pension would put employees, the retired employees, to untold hardship in the difficult days like this, when bread is costlier than blood. First of all, how a retired employee will be able to hold his body and soul together without any pension? Come on, even when the last month salary also not being released.
Yes, February 2020.
Come on, needs to be imagined. First of all, the state and its employees, the state and its officials have to conduct themselves as the model employers, as held by the apex court, as observed by the apex court. 2013 Supreme Court. Can you say that judgment?
Yes, it's state of Jharkhand.
No. State and its
State of Jharkhand and others versus Jitendra Kumar Srivastav. 2013
employers, model employers. Hazarika. Bhupen Hazarika versus State of Assam. Society. First, there is absolutely no reason or right for withholding the pension and other terminal benefits of the petitioner. First, this is a fit case for levy of exemplary costs, so that such things would not happen to other employees who are going to retire or who have retired. First of all, the retired person should be treated with honor and dignity. He is as a constitutional imperative under the directive principles, since they are in the evening of their life. First, the way the petitioner has been given an unfair treatment, if not cruel, cannot with impunity. Exemplary costs need to be levied. First, last couple days matter. So it's within 8 weeks per annum. Well, wait. The OPs, which OPs?
1 and 2.
OP numbers 1 and 2 collectively shall pay a cost of rupees 1 lakh to the petitioner within a period of 45 days, because for appeal 30 days.
May I say, may I submit one thing?
Yes.
Prior to that. The impugned order dated 2/12/2023.
Correct.
I'm only pointing out the date. The order of the police authority, which is end to this proceeding, is on 30/12/2023. My contention is 2/12/2023, the impugned order is there. By that time, the police final investigation was not there.
Now, how you are concerned?
I'm coming, my lord, for a moment, my lord.
You were not a party, you were not a complainant.
But it was within the knowledge of the authority.
Correct.
For that purpose.
Now, how within the knowledge? It should be officially communicated to you, or it should be something to do with.
Because scenario was there.
You made a complaint.
No, we have never complained.
Then leave it.
But crime branch was there.
It is between two persons.
So only it is 1 year back. Then impugned order was challenged. This is the writ application.
You could not have awaited that.
So only 1 year there, we are outing the decision of this Hon'Ble Court.
No, otherwise, see, the exemplary cost is to tell the government, if you treat the retired employees this way, this will be the consequence.
My lord, because
how are you going to protect?
My humble submission would be, I am not saying anything about the cost. My humble submission,
50,000.
My humble condition, only the date, my lord, December and the February. So far the February, the impugned order is concerned, that is under challenge, which is arising out of that particular date.
It is
1 year, my lord.
Second, I would have understood if you had, after seeing the police report, you should have sanctioned the court. Already police report has.
My lord, by that time, writ application was filed.
The way. Well, there was stay of taking any action against sanction.
But notice was issued, my lord. We are hurting the decision, my lord.
Why?
My submission is more for that purpose.
When a citizen comes to the court saying that I have this problem with this officer, that officer can set aside whatever bad action he has and tell the court, yes, sir, matter has become infectious. We have given justice to it.
It is not for a long period, my lord. I am conscious, my lord. It is my duty to point it out.
It's not one case. It should become a pillar.
No, there are many cases. Before one case, it was long delay was there. So far, this matter is concerned. So, in fact, the interest is there. But my lord says that fell from my lord's mouth.
That question of interest is 1983 Supreme Court.
Yes, ma'am.
That Padmanabhan Nair versus Swines. Cost is to alert the inert government.
But here,
unless some chabka says something, it is given.
In this particular case, I am not in other case, particularly in this case, when December it has been come out, and by month of February, so this is my innocuous prayer, my lord.
Is very fair to you.
Yes.
This court intended to levy a heavy cost of rupees, exemplary cost of rupees 1 lakh. However, it refrains it from doing on the passionate submission of learned AGA Mr. Mohanty and the grace shown by learned counsel appearing for the petitioner. First one. But costs become payable if this order is not complied with.
Go down, my lord.
In time.
Deeply go down.
Say cost become payable if this order is not complied with
time stipulated
and within the time stipulated, and compliance report is not submitted to the Registrar General of this court. Okay. So
that's fixing it to 8 weeks.
8 weeks.
In
all cases now, hereafter, cost will follow. We have to develop the cost jurisprudence because accountant.
My lord, in the morning, my lord says,
yes.
From that. May I say, my lord, being the officers of the court, and the Advocate General is also the first person to advise the state so far the legal aspect is concerned. If at all the same thing will be decided in amicable out of the court, my lord, they will be more alerted. By that, these things will not
I agree.
Arise.
I agree.
I am fairly submitting officer. It is my duty, my lord.
I agree with you. I agree. In fact, there is one judgment of Lord Denning, how the government advocates should conduct themselves in the court. You are not the advocate for the government at all.
No, my lord, we are there to assist this court, my lord, not this way or that way. I am not on that.
Correct.
We are the officer of the court, only to assist the court. Beyond that, we don't have any scope and ambit. I am conscious. I am conscious.
I should tell one thing. Palkiwala wrote a letter to Soli Sorabji. When Sorabji became the Attorney General, he wrote, "My dear Soli, so and so, so and so, so and so." He quotes a particular write-up printed, it's carved on the wall of the US Supreme Court, saying, whenever citizens wins against the state in a legal battle, the state celebrates it. The loser party who has lost the battle, celebrates the victory of the citizen. The grace of the state, because justice is done to him. That should be the approach. But unfortunately, that is not. The stand, very often I say, of course, you are very fair. All the three of my, 3-4 persons in my court hall, they are very good. Very good. They do their job and they leave it. But unless, therefore, very often.
We are in such a mechanism,
Yes.
but
What is this? How much money is spent on? How many times they should come to court? I am fed up with the very jurisprudence of this court. First contempt, second contempt, third contempt. Consider the representation.
Lord, with the due humiliation, we are there to file the contempt. Court is there to pass this order. Unless the second contempt will not be allowed, then definitely it will be implemented so far the first order is concerned. With the due humiliation.
There need not be contempt at all.
Exactly.
The state should simply comply with the order.
And it is a recent development. It was not there, my lord. While Hansaria was there, subsequently it was not there, my lord.
It has started with first contempt that from Karnataka only.
Because people come here. See the designation.
Hanumantappa. Justice Hanumantappa.
Justice Hanumantappa, while the chief justice of this court.
2 months time at the relevant time.
Anyway, times were very different those days. What I suggest is, I tell you, nobody comes to court with happiness. Have you ever seen anybody coming with happiness except these 2 girls as interns? They are very happy because they want to learn. For rest of the people, it is a torture.
About court and medical, nobody is coming with this.
Hospital, no.
Obviously.
It is like a
It is with the compelling circumstances. Compelling circumstances.
Nobody comes to court. Left with no alternative. They come to court. This is the only hope of the country now. Courts are the only hope. No other institution. I'm sorry to say this. No institution comments the respect which our constitutional courts and subordinate courts, district judiciary comment. No other way. Therefore, I always request you to protect the dignity of the institution. Even judges may commit some mistake, etc. Then don't worry about it. But institutional integrity, which includes the dignity of the lawyers, dignity of the judges, dignity of even Jameda, because all they together constitute this institution. Not only bar and the bench. We are only boasting bar and the bench, etc. What about the people who work till 8:30 every day? We never appreciate them at all. Anyways, let's see. Can you grant me leave to go because I have one library meeting?
But I have a problem. I may go, but this next item, kindly recollect that man will be retired on 31st. One of these petitioner, this is for regulation. I 31st will retire. Day before yesterday it was there. And because my lord is going, I am behind this case. Can you be taken up tomorrow first case? Because if it will come again in the roster, I have to wait up to 4 o'clock and the same.
But even if I pass order today, the effect of the order will be after retirement only.
No, effect of the order, I don't know whether I will win or I will lose. If it will go positive, then if I will succeed,
positive because last time we have argued that.
Yes, ma'am. If it will be, then that may will retire.
To some extent covered by the judgment also.
This could only one point they have stated, entire argument, and my lord senior has also placed that 12/4/1993, they have set a cut-off date. Government has no NMR employee appointed after 12/4/1993 will get a regulation. Rather, the Finance Department circular letter that is for the engineering department. Be that as it may, my lord, this honorable court in a recent judgment has held that finding to be arbitrary. That particular resolution was taken note of, that particular stand was taken note of, and says this is arbitrary and direction for regulation. So in this case, if one will be retired on the 31st day after tomorrow, at least nothing in the paper. No. I want the vacancies were there, my lord. And a person, let him get some benefit at least. I'm not against that. No. Before 30, my anxiety is 31st. Otherwise, nothing, my lord.
If a person gets the benefit, the same benefit, learned council also get the share of that.
Yes. Then can it be only tomorrow, my lord? First case. Otherwise, my lord, the main will
happen. Let's see that. But anyway, if you succeed, we'll see the kind of order I make it.
That's true, my lord.
Very bad in injury.
That is true, my lord. But now we have to face the person also. When I have returned back to my office and that man will come, I will have no answer. This is kindly see the peril I have been doing.
You tell your client, very bad judge from Karnataka has come. No use at all.
They are looking at you through this online. So whatever I will say, that makes no difference.
I will have not tomorrow, brother, I tell you.
My lord, difficult. At least for this case, day of your yesterday it was there. My lord, fixed to 24th, before vacation also. It was there. So we
will put an end to this matter.
Tomorrow, my lord, at least 30 before 31st.
No, not for.
Because day before yesterday it was there. I was asking for
yesterday. I remember. You can tell your client that matter will be taken up on 20th of how many matters are posted on 20th?
My lord, that's same.
That's 10 matters.
Huh?
10 matters.
10 matters.
Sir.
You add this also.
Sir.
My lord, 20th of November.
Because next week I have not yet.
No, next week I should not have prayed for. Only I pray, my lord, if Michael, my lord, I will only take whatever I have stated,
On 11th.
Tomorrow, if it will be.
11th. Tomorrow, very difficult. Kindly, you have to resist your temptation to.
Only thing, my lord, when I look at that person, my lord, that is my anxiety. Otherwise, I am doing every case.
Look, he is one of the petitioner. There are other persons who are smiling also.
No, they are those faces. Equally there.
11th of October.
May I take the leave that I will make a mention, then it can be that there must be this case on that date. Because I don't know what will be the roster. How many cases it will come. Today, why not see 75 items before my lord.
It's very difficult.
Item 67, my lord.
My lord, figure number 67, my lord. The petitioner has been retired since 2021, my lord. Still that he has not getting the retirement benefit, pension or other retirement benefits, my lord. There is no proceeding, anything, nothing else, my lord, against him.
Which item?
67. Instruction was sought for. Why the
67?
Yes, my lord.
Mr. G, let me see. You have to take cue from our today's judgment. Yes. In other matters, I have not.
68.
Just as giving them, it is like saying, thief has returned the goods, therefore leave him. No. For taking the goods, thief should be punished even when goods are returned. By returning the goods, justice is not done. By imprisoning the thief, justice is done. Therefore, from this you should draw your conclusions. So today's order, I have not waived it. I have made it conditional, contingent, only contingent. But next matter, I don't know whether I will make it contingent. I want to be little curt to the state and its officers and the universities and the institutions. That you should tell to your consideration. I am telling you now. Whichever case non-consideration is there, if you file a memo that it will be considered within 2 weeks, 3 weeks, etc., I may not impose cost. On your side, it should be straightway admission, saying that, yes, we are filing a memo. You keep 1 dozen memo ready also, so that you can escape levy of cost. Otherwise, if he succeeds here, cost should go to him. At least minimum 10,000-20,000 rupees, because they have engaged a lawyer. And for getting an order to pass order, they have to pay. That is no justice at all. It is only order. Therefore, in this I am putting to you. Some new trend has to be found out now. Otherwise, they will lose faith in the judiciary. Already they have lost that. But whatever little is left now, even that will be lost. Judges are very proactive.
59 million. 68 minor.
67
That item, 68